Board, August 17, 2026. This meeting is being held in accordance with the New Jersey Open Public Meetings Act. Notice of this meeting was given on August 7, 2026 and has been posted on the official bulletin board in City Hall, posted on the city's website, and published in the Vineland Daily Journal. Could we all please stand for our flag salute? I'd like to call this meeting to order and have our roll call, please.
Mr. Menz?
Here.
Mr. Tobolski? Here. Mr. Reel? Here. Ms. Velez? Here. Ms. Andrioli? Here. Mr. Odorizzi?
Here.
Dr. Arthur? Here. Mr. Catalano?
Here. So a few comments before we start this evening, just so we're all aware of how the flow of tonight's meeting is going to go. First off, for all of those that were here for the opening meeting, we appreciate your patience from that night and then coming again this evening. Just so you understand how a planning board meeting does run, it is always the procedure of a planning board meeting that the applicant has their opportunity to put to make their application, to bring their professionals in, to answer the questions of our professional staff. So that procedure is always that the applicant goes through their entire program first. In the meeting of this, of course, with all of what's involved with this application, there were several professionals that needed to be sworn in. And then we also took the opportunity to have those professionals cross-examined by attorneys that were representing people of the opposition. So obviously that took the meeting much longer than really any other planning board meeting that we've had. We do not have specific rules as to how long a meeting can last. Our only rule is that no new application can start after 10 p.m. and obviously that wasn't the case, so we cut the last meeting off at midnight. For tonight's meeting, we will, as the meeting flows, we will make a decision during the meeting, the length of the meeting tonight and where that will go. When we get to the public comment segment, which is going to be the majority of this meeting, and we will ask people to come up, there will be the attorneys will get their opportunity first. And then we'll ask the public to come up. Again, in the planning board, we do not have the same rules that city council has. So we do not have the 5-minute time limit that city council has where they run the timer and that's all the public can speak. However, we would like everyone to show, really respect for the amount of people that are here that may want to speak. And we would ask that you keep your comments to that 3 to 5 minute mark. We're not going to cut anyone off. Unless you get to a point where everything is just repetition of something that came up previously. If you want to agree with a previous person, you can certainly say that. That will be on the record. It will carry the same weight. But if you're speaking and continually go through the same thing, we may ask you, again, for respect for everyone else in the audience, we may ask you to move on for your topic. So that's the way we're going to do it as far as the amount of comments that we're going to have, and we will be here as long as the public wants to continue to speak. Also, the last thing I'll mention before I turn it over to Mike is that the planning board can only vote tonight on what is in front of us tonight, and that is this application. We cannot vote on something that's previously been approved or disapproved. Only thing that we can vote on, if we get to a vote tonight, is the application that is in front of us tonight. So with that being said, I'll turn it over to our solicitor, Mike Malinsky, who will swear in our professionals and offer some comments.
Can all the professionals please raise your right hand? Do each of you swear to tell the truth, the whole truth, and nothing but the truth this evening? Please state your full names and positions for the record.
Kathleen Hicks, Supervising Planner.
Ryan Headley, Board Planner, Board Engineer.
Thomas Lee Spinoni, Consultant to the City.
Gregory Means, Consultant to the City.
Okay, I'd like to have a motion, please, to open the public hearing.
Second.
Roll call.
Mr. Casadia?
Yes.
Mr. Menz?
Yes.
Mr. Tobolski?
Yes.
Mr. Reel?
Yes.
Ms. Velez?
Yes.
Ms. Andrioli?
Yes.
Mr. Odorizzi?
Yes.
Dr. Arthur?
Yes.
Mr. Catalano?
Yes.
The way we're going to go this evening is we left off with Mr. Ray. Hello? Hello? All right. The way we're going to proceed this evening is we left off with Mr. Ray Went, who represents Andrew and Stevie Gresh. He's going to continue to proceed with his witness. As part of housekeeping, Mr. Went submitted objection exhibits 1 through 5, which were marked Grosh Grosh 1. That's going to be changed to mimic what's in the exhibit list. So what's listed as Exhibit 1 will now be Gresh 1, and what's limited at number 2 will be Gresh 2, number 3 will be Gresh 3, number 4 will be Gresh 4, number 5 will be Gresh 5. There's also been exhibits that were submitted that were just handed out to the board, which Mr. Went will be introducing. We will pre-mark them as these are Gresh objection exhibits, August 17, 2026. Starting with number 6 through 11. So number 6 will be Gresh Exhibit 6, Gresh Exhibit 7, Gresh Exhibit 8, Gresh Exhibit 9, number 10 will be Gresh Exhibit 10, and number 11 will be Gresh Exhibit 11. This will proceed similar to last time. Mr. Went will present his witness, Mr. Fellinger, his witnesses. Mr. Fellinger will have an opportunity to cross-examine those witnesses. Then we'll go to Ms. Bellevue and Mr. Parks, who will have an opportunity to present their witnesses on behalf of Sustain New Jersey. Those witnesses will also be cross-examined by Mr. Fralinger, if he has any. Then Mr. Fralinger will have the opportunity to call any rebuttal witnesses, which Mr. Went and Ms. Bellevue or Mr. Park will have a chance to cross-examine. And then we will get to the public comment. So with that being said, Mr. Went, call your first witness.
Members of the board, good evening. My name is Ray Went of the Went Law Firm. We're going to start after I go through some exhibits and introduce them. Initially, we're going to swear in Andrew Gretsch. He's with 1661 Hansbridge Road. He's also joined by his wife, Stevie Gretsch. And hopefully I don't get too much feedback on this microphone. So as your solicitor mentioned, I'll step back a bit. As your solicitor mentioned, we have a number of exhibits, Gretsch 1 through 12. We're going to introduce a Gretsch 13, which is a BPU petition that's dated February 2, 2026.
Right. I only have Gretsch 1 through 11 that's on here.
Excuse me, Gretsch 12 will be the BPU petition dated February 2, 2026. Mr. Gretsch will speak to that briefly. Again, just by way of background, so you understand where the Gretsch residence is located, we've attached this as Gretsch 2. An aerial photo and some photos of the Data One site. But the aerial photo shows you where the Gretsch property is in relation to the Data One project. Gretsch 3 is the noise measurement reports and the county notice of violation. The Gretsch family, among others, submitted complaints to the county, which the county has diligently followed up on and issued notices of violation regarding the sound issue. We've discussed ad nauseum, but Mr. Gretsch will talk about his family's personal experience with the sound situation as well. We also have, as a follow-up to our discussion on the use variance issue, which again, we maintain the use variance is required for this particular application and the prior applications for that matter. We've attached a copy of the ordinance that's on file that changed the zoning, which is ordinance 2022-44. That's at Gretsch 6. Interestingly, the map that's attached doesn't mention what type of zone it was before it was changed, which is usually something you see. But it also has some problems because you're going to see some residential districts still within the zone. So again, there's a lot of confusion about what this zone is and is not, especially with respect to the approval of the amendment and the map itself, which again, I hate to beat a dead horse, but I'm going to keep beating it. It's the wrong map on the website for years. We've also attached, for your consideration, the Vineland and Hamilton land use regulations with respect to what is a permitted use. Very, very similar language, and I can represent to you that Hamilton takes a position of a specific application to its use variances. Specifically, if it's not in the code, a specific use, it's prohibited. We think that Vineland should take the same approach as you heard from our expert last meeting. This use is specifically not mentioned in the business industrial zone, and as such requires a use variance. We've attached your code as Gretch 80, section 425-289 of the IB zone, so that you can again see that there's nothing that reflects anything that would show that this use is permitted. As Gretch 9, we submitted fire official Murray's email dated July 24, 2026, attaching the fire prevention code. This is interesting because it is a laundry list of things that your fire official has problems with respect to this property. It speaks for itself. It's a public document. I'm not going to testify on his behalf or ask my client to, but it's something that you should consider because it's important. Even if, assuming we put the use variance issue aside, you have discretion here tonight. If a site plan is presented to you and you don't have enough information to make a decision, you can say no. If you're concerned about safety issues, health, welfare, and safety, ingress, egress, the ability of first responders to get to any area of the property or surrounding properties, you can say no. The fact that a variance has not been applied for here, even though we say it should be, does not stop you or divest you from that power. So, in listening to everybody tonight, we respectfully request that you keep that in mind, that this is not a rubber stamp. This is very important, and you do have power and discretion that's vested with you tonight. As Gretch 10 and 11, interestingly, on August 6th and then August 10th, respectively, the Gretch 10 being August 6th, a stop construction order was issued by your city, and then on August 10th, another stop construction order was issued by your city. It's sort of a classic example of do what you like now and ask for forgiveness afterwards instead of coming for permission first. And that seems to be a little bit of an MO here. So, fortunately, your city is paying attention to what the residents have to say into this application and did what it needed to be done and issued those stop work orders, and those are now part of the record. Now, lastly, it's not on your index, but it's going to be marked as Gretch 12. It's a DPU petition dated February 26, 2026. Mr. Gretch will speak to that and his concerns, but as an overview, you'll see that there was a request for a 125 megawatt facility. This is less than a year ago. This is less than 3/4 of a year ago. So you've got an applicant that's telling you one thing and is telling the DPU another and is telling other agencies another. We know that you don't have jurisdiction over certain issues, and that's why they have to go to other governmental entities. But it's important to know the pattern of conduct that is occurring with these applications. Because DPU, as far as they know, it's going to be a 125 megawatt facility. And that's important. And I use the classic example of oftentimes DEP, the board will say, well, it's a DEP issue, it's not our jurisdiction. Well, sometimes they overlap. And I'm from down the shore, and I deal with bulkheads a lot. And DEP regulates bulkheads. But you better be darn sure that under Margate, Longport, Atlantic City, Sea Isle, Cape May, Wildwood, and everybody else that has bulkheads and properties with bulkheads, they also care about bulkheads too, even though it's a DEP jurisdictional issue. So the fact that something is quote unquote a DEP issue or an air quality control issue or a BPU issue should not mean that you don't consider it in your decision tonight. And that goes to the overall application. Do you have the information you need to make a decision tonight? We say no. Do you have information that should concern you? And you're going to hear from colleagues with respect to stormwater, and you've heard about a lot of your environmental issues, which is way above my pay grade. That should give you pause before you say yes to this. In fact, should make you say no, irrespective of jurisdiction. They go to health, safety, and welfare, even if they are jurisdictionally DEP issues or BPU issues. They're your issues. They're Vineland's issues. That's why you're here. That's why we're here. So with that, I'd like to swear in Gretch to speak a little bit about his personal experience with what's happening and how it's affecting his property. He is not the closest, but he's pretty close, and that's why we're here. I'll bring up these the BPU petition that you can pass out.
Mr. Gresh, can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth this evening?
I do.
Okay, please proceed.
Since we have one microphone here, and we're not going to stand too close to each other, I'm going to ask a few introductory questions, then I'm going to let Mr. Gretsch speak on his own rather than do the traditional trial question and answer scenario, if that's okay. Mr. Gretsch, earlier I identified the aerial photograph from Marcus Gretsch 2. Is that an accurate depiction of your property in relation to the Data 1 Center?
Yes, it is.
With respect to, and then in number 3, the noise measurement report from March 10, 2026, are those readings from your property?
I believe so. There were several that we got in the open request, and the addresses were redacted, but it was one of many.
Why don't you tell us about the noise issues at your property?
Yeah, so started roughly fall of 2025.
Can you get the microphone, please?
Sure, yeah, no problem. Yeah, around the fall of 2025, I would put my children to bed and hear this humming sound going off of the windows in our house, off our metal roof, and it would never go away. Typically proceed at night, continue through to the morning. Very disturbing. Keep me up in the middle of the night at times. I think as recently as last week, I was sitting in my living room and just waiting for my air conditioner to come on to drown out that other noise. Some of it made me feel anxious, kept me from sleeping, all the above.
Yes. Why don't you go through what you've written down? It's okay to have any notes and to look at your notes and read a little bit if you need to. There's a lot going on here. Nobody has to memorize everything. So if you would, walk the board through your outline, your concerns for you and your family.
Yeah, absolutely. So originally this application, not this application, but one for the client was brought up in 2024, at which time the attorney for the for Data 1 or whoever was applying had said that data centers virtually have no noise to them, and also that power generation would be heard if the power went out, backup power generators. For a reasonable person like myself, you would think that means when power goes out, which doesn't happen very often. So it wasn't a big concern. And I'm sure it wasn't for many of you when you heard that application. It was ambiguous in nature, and I'm not so sure that it wasn't intentional at the time. And now today, what I believe we hear are generators at the site, and they're not just for construction. They're used to primarily drive the business model, which is data processing, and that's not what we were originally told. So anyway, now we're here today, and we're looking at another application that may or may not have some ambiguity to it. One of the big things now is power generation, which was approved in 2025. But here we see the LNG storage tanks. You guys heard plenty about it last week, but we don't know really to what extent they're going to be used. So we were able to look up in that document that was just handed out, Reg 12, that was in the BPU, paragraph 7 of that document. It mentions the pipeline was sufficient to deliver 125 megawatts. We know now that they want a data center that's good for 300 to 350 megawatts. So I have to question, where does that gap come from, right? Where's the gap? And I assume it comes from gas out of those LNG tanks. And perhaps I'm wrong, but this is all I have to go off of, because they haven't actually said if it's for backup emergency situations or if it's for daily operation.
I'm going to interrupt you briefly, and you've been here, I've been a little bit busy. Have you heard any testimony about how often they're going to have to transport this LNG? How many trucks are going to be required to transport this LNG?
No, no one's made mention of how much traffic of LNG tankers that there's going to be. We did see there's like 4 bays on the LNG tanker, if I'm not mistaken, the exhibit we saw last week from the applicant. So that would imply that there's going to be a relative frequent usage of those bays, and trucks could be coming down, based on some of my numbers, was 20 to 25 trucks a day of LNG. To my knowledge, there isn't a current LNG tank going down Route 55 at all right now. And some of the closest filling stations for LNG trucks aren't around here. So how is it going to get here? How often? How many? I think these are all important things for the board to consider. I also, in the previous submission, we had exhibit number 5. It was a study that was done back in 2013, and it identified Lincoln Avenue as the 3rd highest accident rate per mile. So if you want to introduce a bunch of LNG trucks, in addition to all the recent addition of traffic with Northeast Precast and associated facilities, I think you may have a problem there, and something to be concerned about. I know they didn't describe an LNG tanker as particularly dangerous last week or 2 weeks ago, but I've seen some information that proves otherwise.
Now, just for the record, so we're being completely transparent, there were discussions with the applicant's attorney and myself about getting noise readings. We did reach out. It was later in the week. It wasn't until about Thursday when I reached out to Mr. Frailinger, and I said that the Gretsch family would like readings done from their property line, and they'd like it done between 11:55 p.m. and 3 a.m. Mr. Frailinger immediately responded within minutes, and logistical issues are a problem for his expert, but he is available next Monday, Tuesday, and Wednesday, I believe, to get out there, and so hopefully we can have those readings. But we don't have them right now. But in the interest, again, of transparency, we did reach out. They reached out back, and hopefully we have some good readings, and I encourage others to do the same if you are in the neighborhood. Because Mr. Frailinger was good about getting back to us. Didn't mean to interrupt, but wanted to just touch upon that.
Nothing specific otherwise, any of these exhibits, I think we touched on most of them.
Just one question. What's the address, your actual address you're on Sheridan, correct? Or you're on?
1661, 1661, Hansbridge.
Thank you.
Certainly. We know you have a lot of interested people here tonight that have real concerns, as do we, so we don't want to belabor the point. Again, we think a use variance is required. We think we give you, along with our expert and our exhibits, all that you need to see that a use variance is required. Maybe more of an expert issue that you need to talk to professionals about, but that's a threshold issue that's very important. We're obviously preserving all other notice issues with respect to prior approvals, which you're not dealing with tonight, but I'm just saying that because I'm a lawyer and I have to. Again, though, to close, and you're going to hear a lot from a lot of people to give you what you need to say no tonight. You have the discretion to say no. It does not have to be a variance application. This is not a by right subdivision. You have the discretion to say no tonight. That's all we have, unless somebody has questions for my client. That will conclude our presentation in chief. Thank you.
Mr. Vineland, any questions?
No, I don't have the questions.
Mr. White, no more witnesses?
No, that's it for us. Thank you.
Thank you, Mr. White. At this time, I'd ask Ms. Bellevue and Mr. Parks on behalf of Sustain New Jersey to present their first witness.
Hey there, thank you very much. Colin Parks, P-A-R-T-S, T as in Thomas. We're representing Sustain South Jersey, not Sustain NJ, sorry, just to clarify. Today, we'll be calling Clay Emerson first. Mr. Emerson, will you please introduce yourself?
Yes, good evening. My name is Clay Emerson. Last name spelled E-M-E-R-S-O-N.
Oh, he needs to be sworn in.
Oh, I was intending to. I just wanted you to get his name for the record first.
Can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth with regard to this?
I did.
I would ask you to please state your full name for the record, but you already did. Proceed.
Sorry for flipping the order. Clay, where do you work?
Yes, I'm a civil engineer, and I work at a company called Princeton Hydro. It's a consulting engineering firm.
What do you do there?
I'm a professional engineer, including in the state of New Jersey, and I am a water resource engineer. My focus is stormwater, hydrology, floodplain calculations, and things of that nature.
And how long have you been doing this type of work?
For approximately 18 or 19 years now at the company where I am.
What's your educational background?
Sure. I have an undergrad degree from Rowan University, a master's degree from Drexel University, both in civil engineering, and a PhD from Villanova University. I've also been an adjunct professor at Rowan University, and I'm still currently the same at Villanova University in the College of Engineering.
And you mentioned your licenses. Are you licensed here in New Jersey?
I am in good standing.
Are you familiar with state and federal stormwater management requirements?
Yes, very. It's a large part of what I do at work on a daily basis.
And are you also familiar with state green infrastructure requirements as they relate to stormwater management?
Yes, absolutely.
At this time, I'd like to enter Mr. Emerson as an expert in stormwater management, groundwater management, and green infrastructure.
Any objection?
No objection.
Please proceed.
So, Mr. Emerson, what were you contracted to do in this case?
I was simply asked to review the application with a focus on stormwater management with the specific purpose of determining whether or not the application that's before the board tonight is compliant with your local stormwater ordinance.
And did you apply standard principles and methods when you conducted this evaluation?
Yes, I did.
Did you prepare a report? Let's see. Did you prepare a report with your conclusions? Excuse me.
I did. I prepared a report that was submitted prior to the previous hearing dated August 4th, and then a second supplementary report dated August 17th.
At this time, we'd like to introduce both of those reports to the board.
The August 4th report will enter in as Earth Justice 6, and the August 17th report will enter in as Earth Justice 7.
And just as a matter of housekeeping, we do have 3 slides at the end. Should we call those, I think you said 7, so maybe 8, 9, and 10?
The 3 slides are all part of one PowerPoint presentation?
They should all be part of one PowerPoint.
Yes, then I'm just going to call them Earth Justice 8.
Earth Justice 8 sounds great, thank you.
It consists of the 3 PowerPoint slides.
Mr. Emerson, were you able to draw any conclusions about the plans that you reviewed for this project?
Yes. Through a detailed review of the same application materials that are available to you, it is my professional opinion that the stormwater aspect of the application is not currently compliant with your local stormwater ordinance.
Great. So let's take the report piece by piece, starting with soil testing. What requirements was Data 1 supposed to meet for its soil testing?
Yes, the rules and the supporting documentation from the DEP is very specific on what testing needs to be done to ensure that systems are designed properly and will function. And that includes soil testing, as you mentioned. They have very specific requirements on the number of soil tests you need to do per basin, the exact locations of those tests, and so on and so forth.
So with the locations, do the locations of the soil tests, as you reviewed them, correspond with the locations for the proposed basins at the site?
No, they do not. It looks like they were laid out at a time when perhaps a different application was in mind by the applicant, because they are somewhat unrelated to the locations where their stormwater systems are proposed, and they're required to have those soil investigations at each proposed basin.
In your professional opinion, is the location of those soil tests appropriate?
No, definitely not.
So let's talk about specifically the basins at the southern end of the site. Do the basins at the southern end of the site have test pits that are at or nearby their proposed location?
No, they do not.
What about the depth requirements for soil testing? Did Data One soil test pits meet their depth requirements?
No, and again, that DEP guidance that I mentioned before has very specific requirements on not just the locations in plan view, like in space, as you look down at the paper, but also how deep you need to go, and that wasn't compliant either. And I think this is one of the points that was also raised by the city in their review letter.
So to establish the stakes here, what's at risk when you don't have accurate data from your soil testing?
This is one of the most important considerations when it comes to stormwater design, and it's something that I've spent a lot of time looking into, including working with the state in developing some of the guidelines that they have. And if you get these things wrong, systems won't function as designed. And I think it was just, I don't know, within 10 or 15 years, when there was another application in the city where a system was designed and the applicant made some errors in that soil testing. They specifically made an error on determining the seasonal high groundwater table, and this was before Mr. Headley's time here. This was with David. And I think that issue is only just recently being resolved there on Brewster Road, where mistakes were made in that soil testing, and there were real consequences for the adjacent property owner and for the city.
And just to be clear, when you say real consequences, what are those real consequences?
Yeah, in that instance, the adjoining property was flooded periodically from outflow from a system that wasn't working as it was intended because of some of the same mistakes we're here to talk about tonight.
So is this problem with Data One's soil testing something that they can address without retesting and potentially redesigning their plan?
I don't see how you can design a stormwater system and expect it to work if you don't have the appropriate soil testing before you do the design. And that's why DEP has very prescriptive guidance on what to do and where to do it.
So next, I'd like to talk about maximum contributory drainage area. In your report, you talk about the maximum contributory drainage area. Can you tell us what that is in plain language?
Yes. A few years ago, DEP made what's a pretty substantial change in their rules, and it's this concept of green infrastructure and the definition of green infrastructure as the DEP designs it. Part of that definition is to manage stormwater close to the location where it's generated. And that may not mean much to you, but I can kind of present that in more of an example. So the typical approach historically in the state of New Jersey has been to build the building, build the parking lot, and then at the very bottom of the site, that's where you stick your single stormwater basin. And that wasn't working generally in the state of New Jersey. And New Jersey followed the lead of other states and put this green infrastructure rule in place that said you can't put more than 2.5 acres of contributory drainage or 2.5 acres of, say, a parking lot into a basin. That's the limit. And what that does for applicants who have large sites like this that are more than 2.5 acres means they can't just have one big basin at the bottom. They have to have smaller basins distributed around the site.
And last time, you were present at the hearing last time, correct?
I was.
Last time, we were told that Data One's basins all satisfied this maximum drainage area limit requirement that you just explained. Is that correct?
We did hear that, but I firmly disagree with that.
And which basins don't satisfy that requirement?
Most of them, most notably Basin AH in the front and Basin S in the bottom, which we'll share in an exhibit later.
And what are the consequences if a basin exceeds the maximum drainage area limit that you're talking about?
Well, first and foremost, it's just that means the application is not compliant. The rules say that the limit is 2.5 acres, and if you don't have that, then it's not approvable in its current format. So again, DEP, in my opinion, put that rule in place to ensure that these structures work as designed, as intended, and you know, by spreading those basins across the site and not relying on one or two large basins at the bottom of the site.
And you said that Data One's basins don't satisfy this requirement. Is that something they could fix without redesigning their stormwater management plan?
No. In my opinion, definitely not.
Now, Mr. Emerson, your report does talk about one way you think Data One seems to be trying to get around this limit, which are water quality basin separations. Can you tell us what those are, what they look like?
Yes. So they refer to them in the plan as water quality separators or separations, as you said, and that's not recognized by DEP. When that rule first came out, that green infrastructure rule, there were a couple early applications that said, well, we're going to do things the way we always did. We're going to put one basin at the bottom of the site, just like we've always done. But instead, we're going to put some clever dividers, so that the pipe kind of goes into, to chop up one large basin into a number of small ones. And very quickly, DEP put out what I think is pretty clear guidance that does not meet the rules.
At this time, can we refer to the second slide in that PowerPoint, which I believe is Earth Justice 8? Just one more, please. That's the one. Clay, can you explain what we're looking at here?
Sure. So, as I indicated, when this rule first came out, a lot of developers, or I should say engineers, said, well, we're going to put our building and our parking area just wherever it's most convenient or however works best for us. And we're going to take that one portion of the site where we normally just build one big basin, and we're just going to put a bunch of small ones down there. And because of that confusion and because of people wanting to try and take the shortcut, they even came out with this fact sheet, which that URL references. And this is the figure from page 3 of that fact sheet that is only there to show you how this approach, quote, does not meet the rules. In other words, don't think that you can put a building and a parking lot and all send it to one place and just divide a basin into a bunch of small ones all in the same place and comply with this rule. This does not meet the rules.
Clay, you said that there were two basins that are definitely not meeting the maximum drainage area requirements. One of those basins was Basin S, right?
Correct.
Can you please go to slide 3 for us? Perfect. Clay, what are we looking at here?
Okay, and again, as you said, this is just one example from the plans. There are others, but to try and be concise here, we've just shown this one. And this is from page 36 of the site plans, unedited, just a cropped image of that page. And this is Stormwater Basin S, which, as its name implies, is a singular stormwater basin. But what's unique about it, or what's interesting to me at least, I can't say the same for everyone else here, is that they've attempted to divide what is clearly a singular basin into 10 smaller basins with these kind of gray lines going horizontally and one diagonally there. So the application would want us to believe that this is 10 or so individual basins. And this is exactly what the state in their fact sheet was showing is simply not compliant. This is still managing all that runoff, some 50 acres in total that gets here, in one location, in one basin. This is not 10 different basins. The drainage area to this basin is over 20 acres, which is a good bit more than the 2.5 acre limit.
So, Clay, I think the answer is obvious, but does this basin comply with green infrastructure requirements?
No, not at all. It's a great example of what doesn't comply.
And is this error something that Data One could fix without redesigning its stormwater management plan?
So this would be a pretty major change to the plans, right? If you look at the site plans as a whole, you don't see a whole lot of extra places where they can put things. I think we heard last hearing that they're already asking for a waiver for putting retaining walls around many of the basins, including Basin S here. And I bring up that point about retaining walls because that's a sign, at least to me, as someone who sees dozens and dozens of applications every year, that space is at a premium, right? You put in a retaining wall so that you can fit the same basin in a smaller footprint, so you don't have those side slopes. So when I start seeing an application that just visually doesn't have a lot of space left, and I see retaining walls, they're asking from a waiver for you for that, that tells me that, you know, they've got as much impervious area as they can muster, and with the other stuff that we're going to talk about, you'll see that they don't have the stormwater management needed for what they already have proposed. So to resolve that, to come to the question here, that's a pretty major change.
So next, I'd like to turn and talk about water quantity. So we heard last time that there were 6 existing drainage areas on the site, but that there were only 2 proposed discharge points. What's the consequence of only having 2 discharge points for a site this size?
Yes. So the rules, you know, a lot of sites like this straddle different drainage areas, and the rules are pretty clear for all the requirements for water quantity, which is kind of the DEP's version of like flood control. Like these are the things that engineers have to do so that you can design a site that's not going to flood the person who lives downstream. And you have to manage these things in each drainage area. So, and you also have to respect the existing drainage divide, so you're not taking water that used to go one way to certain property owners and sending it another way to property owners who haven't seen it before.
And last time we heard that these 2 discharge points basically mean that it's 2 large watersheds, one of which would just discharge into the northeast precast site. But we were told that that wouldn't be an issue. Do you agree that draining half of this site to northeast precast won't be a problem?
I think it's the applicant's burden to prove that it won't, and that's specifically, you know, written in the stormwater rules that's their burden. Whether or not they own the site is irrelevant. This is a site where the stormwater rules have to be managed at the property line. It doesn't matter who owns that property.
So, just so we understand too, where does the downstream northeast precast basin discharge, the one that's receiving half of the water from the site?
Well, ultimately, the site straddles the direct Morris River watershed and the Menanico Creek watershed, and the applicant hasn't provided information to clearly state where that drainage goes. But ultimately, it goes downstream to someone else's property, that much is for sure.
And in your professional opinion, has Data One demonstrated that the stream or northeast precast could handle this volume of water?
No, they have not.
So next, let's talk about modeling. We heard last time about the hydrograph unit that Data One used to calculate its flow rates. First, everybody agrees that Vineland is in the coastal plain. Is that right?
It is.
And And what hydrograph unit does the BMP manual require an engineer to use for sites in the coastal plain?
Yeah, there is no, I think last hearing it was presented by the applicant that this was some kind of choice that they had. And it is not a choice. The entirety of the city of Vineland is in the coastal plain. And in that instance, you have to use this specific Delmarva unit hydrograph. I know we're kind of in the weeds of the calculation, but this is a nice, simple black and white issue. They're required to use the Delmarva unit hydrograph, not the standard unit hydrograph that they did use.
Clay, we heard that it was only an option to have to use the Delmarva unit hydrograph last time. Is that incorrect?
That's incorrect. It is not an option.
And if using the Delmarva unit hydrograph is mandatory, does that mean Data One's failure to use this unit means they're not in compliance with the state requirements?
That's correct.
So last time, we also talked about land features and modeling at the site. First, we heard that Data One used aerial modeling rather than survey data to determine land cover at the site. But we were told that aerial modeling was acceptable. Do you agree?
Generally, it is if it's done appropriately and accurately, but our review noticed that there were certain areas that were identified as not being forested that were, and so there were inconsistencies, and that's why, especially if you have the ability that ground truthing or first-hand surveying is what's usually relied upon.
So is it fair to say that they're not accurately characterizing the land cover at the site?
Yes, that's correct.
And what's the consequence from not accurately characterizing land cover at the site?
Well, in this instance, the net result of that misidentification is it overestimates the existing discharge from the site. And that's important because that kind of sets the bar. Like the rules are written both for flood control that we're talking about now, and also for groundwater recharge that we'll talk about in a little bit. The existing conditions really set the baseline. So what the performance of their stormwater system is based in large part on those existing conditions. So in the case of peak flow that we're talking about here, the more that they overestimate, in my opinion, the discharge from the site under existing conditions, the smaller their stormwater basins are. It's just as simple as that. So we don't want them to underestimate the runoff. We want them, and they're required to accurately represent that flow rate.
So if there's a risk that they're potentially not accurately characterizing that flow rate, is their stormwater management system likely to be oversized or undersized?
It would be undersized.
And what are the consequences of an undersized stormwater management system?
Downstream impacts, flooding. There'll be more runoff leaving the site faster, additional stress on the city's stormwater infrastructure that's downstream of this site immediately on the case of the site frontage, and further downstream on the other side.
And Mr. Emerson, is this something Data One can fix without redesigning a stormwater management system?
It's not clear that it is. I mean, they would have to do additional calculations to prove that that they are compliant.
And just to be clear, whose burden is it to demonstrate?
Yes, this is to be clear. This isn't the board's burden. This isn't our burden. This is only the applicant's burden.
So next, let's talk about groundwater mounding. At the last hearing, we also heard that Data One had assumed a 150-foot initial thickness of the saturated zone. What is that in plain language?
Yeah, so the whole discussion last time about groundwater mounding, this is, again, kind of getting into the weeds of the design that you have to do. And it relates back to the soil investigations that I talked about that were lacking in this application. But the question I think that you asked was, what are the consequences? I think your question was, according to the DEP, isn't the maximum limit 10 feet? And if you do additional testing, you can assume up to 75 feet. And the applicant here assumed 150 feet. And I can tell you that all that references Chapter 13 of the BMP manual. And Chapter 13 was developed in part by the DEP when these new green infrastructure rules were being considered. And it had a small stakeholder group of about 5 or 6 people, myself included. And also in that committee, I believe, is the gentleman who authored the paper that wrote the tool that the applicant used. He was in that work group. He was a hydrogeologist at USGS. And the group and the DEP came up with that 75 as the upper limit. We heard last meeting that this applicant is using 150 feet. The exact reason for that, we didn't get that answer, but I'm here to tell you that the limit is 75 feet, and the people who had input on that included the people who wrote the tool that the applicant used here, and myself, that 75 feet should be the upper limit.
And what's the impact of using twice the upper limit?
Yeah, so again, what that did for the applicant's calculations is it lowered the apparent groundwater mound. The consequences of getting that wrong is that the groundwater, if you put too much water in one spot and you're trying to get water out of a basin into the ground, if the groundwater table rises up, which it does when water infiltrates into the ground, when it intersects with that basin bottom, if you're too close to the groundwater table, the system isn't going to function, and it's going to overflow when it's not supposed to, which is exactly what happened on the Brewster Road issue that I mentioned before, where we worked with the previous city engineer towards the resolution of that.
So now that we're talking about groundwater, let's finally switch to talking about groundwater recharge. Your supplemental report, which the board has, this is part of Earth Justice's exhibits, discusses Data One's groundwater recharge obligations. First, what is groundwater recharge?
Sure. This is one of the more important, it's hard to pick one, but this is one of the more important aspects of this application, in my opinion. And groundwater recharge is exactly what its name implies. As residents who rely on the city's water supply, or who may own a private well, that water that you're drawing from the aquifer is rainwater that fell on the city of Vineland for the most part, in relatively recent history. And so groundwater recharge, if we were to just pave over the entire city of Vineland, that water could no longer recharge the aquifer, and it wouldn't be there as a reliable water source for residents and businesses alike to use in the future. And of course, the state has recognized the importance of groundwater recharge for decades. This rule's been in place since over 20 years, 2004 to 2006, groundwater recharge. So the state says that you have to maintain the amount of water that soaks into the ground at your property after you build your site. So you're allowed to pave, you're allowed to build buildings and parking lots, but you have to design a stormwater system that ensures that at least that same amount of water is still able to get back in and replenish the aquifer.
And just so we're all very clear on this, what's at stake if the groundwater is not being replenished, if the aquifer is not being replenished?
Reliable water resources, a reliable, sustainable water source, both for private well owners and municipal supply sources as well that rely on this same aquifer. This is, I think pretty self-explanatory in terms of its significance and importance.
So you said that the requirement under the law is that you have to have the same groundwater recharge that existed before the site was built. Is Data One going to meet that groundwater recharge obligation?
No, definitely not. And again, just like I discussed with the flood control requirements, another important part of demonstrating that you're meeting the groundwater recharge is accurately accounting for how much is occurring under existing conditions.
So let's talk about that. Can you describe the existing conditions at the site?
Yes, the site is very unique in terms of groundwater recharge for many different reasons. Number one, it's huge. It's large. It's over 100 acres. Number two, it's in a relatively, I have to use that word here in South Jersey, but it's in a high place. Everything's pretty flat here, but it is uniquely situated, right, as I said before, at a drainage divide between the direct Morris River and the Mananico Creek. So it's really at a high point. The soils in that area, anyone who's ever dug a hole in the city of Vineland knows that generally you're going to find the predominant soil that you're going to encounter is going to be sand. And so the soil mapping in this area is what I would expect. And again, in the coastal plain, it's sandy, it's well-drained soils. It's soils that are ideal for infiltration and for providing groundwater recharge. And finally, and most importantly, perhaps, what makes this site unique is its former mining history. So the site isn't, a relatively flat site like many people in this room's property might be, just kind of flat. No, it has huge closed depressions, holes in the ground, where water that rains on a large portion of the site, close to 50% of the site, flows into these holes in the ground and can't flow out. And yes, they're man-made. It doesn't matter if they're man-made or not. But those are existing characteristics that are unique to this site, on top of everything I said before, that serve to capture the rainfall that happens on the site and soak it into the ground.
Can you switch to slide 1, please? Clay, what are we looking at?
Sure. So this is a figure from page 5 of the Stormwater Management Report. And the only thing that I've done to it is I've shaded in blue 4 of those existing drainage areas. And the reason I've selected those 4 to shade them in blue and talk about them here is that those are the ones that the applicant themselves has identified as draining to closed depressions. So those are areas where if a raindrop anywhere in that shaded blue area lands, where does it go? It flows downhill, right? You don't need a PhD to tell you that. What's unique here is that those are dead ends in terms of surface drainage. Water that lands in those shaded areas doesn't immediately flow off-site, or in most cases ever flow off-site. It flows into big holes in the ground that are a relic of previous mining activity.
So these are the existing conditions at the site. Does Data One's stormwater management plan accurately account for these existing conditions that you talked with us?
No, in terms of groundwater recharge, these conditions are completely ignored.
Can you elaborate?
Sure. The applicant went through a process of trying to reclassify these soils and say that they don't provide any recharge. And there's discussion about this in their stormwater report. It's totally irrelevant to the point I'm making here right now because regardless of whether those soils produce runoff or not, that water, if there is any runoff, is going into these closed depressions and it can't leave the site. It has to either evaporate, which is a very slow process, or soak into the ground via some of these closed depressions, a few of which, or 2 of which, include some regulated wetlands along the southern portion of the site.
So what does Data One give us for the amount of recharge per year using their data?
So they argue that approximately 60 acres of the site, which is even more than is shaded there in blue, provides 0 recharge whatsoever. And then they still go through and use the groundwater recharge spreadsheet, or GSR 32 spreadsheet. You'll hear it referred to as different things. And your engineer will know what I'm talking about. It's the page that was kind of hard to read in the application. The resolution was a little poor. I think we could accurately read the numbers after looking at it carefully. But they use this GSR 32 spreadsheet groundwater recharge spreadsheet to do those calculations, existing and proposed conditions. And that method, that spreadsheet is not able to account for unique sites like this. I want to stress that the fact that this site has all these closed depressions is truly unique. Occasionally, I'll see an application that has them, but it really is a unique characteristic to this site in particular. And that spreadsheet is not designed, not intended to be used even where you have surface water features like this or closed depressions that don't allow the water to flow out of the site. And I will say that we've previously objected to the use of the standard GSR 32 groundwater recharge spreadsheets on applications similar to Data One, like on other sites that have this unique bowl, that goes nowhere. Topography, and that's due to the underestimation of the groundwater recharge resulting from the improper calculation of this methodology. And if you, in our letter, I'm not going to read it verbatim, it's there for you. I have quotes from that guidance that says exactly that. This is not my opinion, this is right from the tool itself. The DEP and the Superior Court of New Jersey, the Appellate Division, have both confirmed this finding as can be reviewed in the matter of Thomas Orban / Square Properties Freshwater Wetlands General Permit number 6, and it has the application number, which was challenged by a nonprofit, and that can be referenced under docket A-3072-1612. And the similarities between that application and decision and this one are plain.
So, Clay, your report also mentions 2 figures, I think, that were given by Data One regarding the amount of recharge per existing conditions. What are the 2 figures that we were given?
Sure. So, again, they use that spreadsheet, that tool, that GSR 32, which is not applicable for almost half of this property. But the result of that analysis was that the site, on average, provides about 5.5 inches per year of groundwater recharge. So remember how I said that's what sets the bar for their performance? And here, that is setting the bar exceedingly low, unrealistically low. Ironically, later on in the stormwater report, in Appendix G, I believe, G2 or something of that nature, in something else where they're trying to justify not doing the soil testing that they're required to do that we started off talking about, they talk about a groundwater model that they did, and in order to kind of calibrate the model to their opinion of the aquifer conditions and the observation wells that the applicant apparently had for some 2 years, they came up there with a recharge estimate of 13 inches per year. So the same application, when it comes time to set the bar, so to speak, their opinion on one page of the report is there's only 5.5 inches of recharge. But then if you dig a little deeper, they have another opinion that is contrary to the first and says, oh, there's actually 13 inches per year happening here. If you just look at statewide mapping, the state does publish the estimates of, not site-specific estimates, but general estimates. They would tell you that on average this site, this 150 acres, is about 13 inches per year, but again, that also doesn't account for these closed depressions. So it's confusing because, again, when the applicant, when it comes time to size their stormwater system, they're setting that bar low at 525. In another place where it's convenient, they say there's 13. The state, just on a baseline, would say they're 13 inches per year. And my opinion is there's far more than that, and they haven't calculated it.
So Clay, even if we do assume just 13 inches, is Data One's stormwater management plan going to get them to the 13 inches?
No. They're ignoring, they're saying 60 acres, we're not doing anything. So they haven't designed any groundwater recharge systems whatsoever for that portion of the site. The portion on the site frontage, basin AH, or maybe it's 10 basins, depending on who you ask, there are problems there with the design of that basin. So if you were to ask me, well, how much groundwater recharge has the applicant proven that this application will provide in a manner that is consistent with the rules, including soil testing, doing the proper mounting analysis, that answer is zero, none.
So, Clay, you were here last time and we heard a couple of different conflicting numbers about how much water Data One would take. Let's just say 8 million gallons, for example. They're going to take 8 million gallons and you're telling us that they're going to give back, in a state-approved manner, 0?
Yes, that's right. And I think it's important to understand for the board, I know there was a lot of concerns about the consumptive water use for pooling purposes, and like you said, we heard that the average was 8. We heard that they intend to have 27 million gallons on hand in any given year. But I think it's important to understand that the water usage here is, there's 2 ways you can deplete groundwater. You can use it for consumptive use to cool the power generation facility that's here. But another way to deplete groundwater is to pave over the landscape and not allow that groundwater recharge to happen in the first place. And they're doing both of those things here. And I tried to think of a good analogy, to use for this. And I failed to come up with one, but I'll tell you what I came up with anyway. It's almost like, the surficial aquifer, the Kirkwood-Cohansey that we all likely rely on for our drinking water, it's a communal resource. So it's kind of like attending a potluck dinner. We all have property in the city, water, rainfall is allowed to soak into the ground, and we use that for drinking water and to support business and industry. But you don't show up to the potluck and don't bring anything. And what they're doing is they're both, they're not bringing anything to the dinner because they're not providing groundwater recharge that happens under existing conditions, but they're still, they're going to eat their dinner and they're going to eat your dinner too, because they also have this consumptive water use without providing the recharge.
So, Clay, just to wrap up, I asked you multiple times whether Data One could fix different issues without redesigning their stormwater plan. And each time you said that they couldn't. Do you stand by those statements?
Yes, I do. And that opinion is based on, not just my familiarity with the rules, also my review of this application, this specific application, and the dozens and dozens and dozens of applications that I see on a yearly basis.
And so, in your professional opinion, does Data One's stormwater management plan satisfy the state and local requirements for stormwater management?
No, it does not in its current form.
No further questions.
Mr. Freeland, during cross-examination, please hold your applause.
Mr. Malinsky, I'm just receiving these reports today. The August 4th report I didn't receive until just now. The August 17th report was actually emailed to me right about 6 o'clock tonight. That being the case, I want to reserve my opportunity for cross-examination of this witness until I can better understand it. However, I will have a rebuttal witness that will be prepared to address issues this evening on it.
Okay, I do have just 2 quick questions, just for clarification. It really is the last part that you just mentioned. Mr. Parks asked you that they couldn't fix the stormwater management. Did you say they couldn't fix it at all, or could they, if they modified this plan, they could have a stormwater plan that would work on the site? Yes or no?
So, I don't have a simple yes or no question. I think at the end of it, I will answer with a more simple yes or no, but the assumption that was built into that question that maybe wasn't clear, and I apologize for that, was can they maintain the currently proposed amount of impervious cover, the number of power generation units, the square footage of the data center, the pavement that goes around it, and still build a compliant stormwater system in whatever room is left? That answer is no. So Can this site ever accommodate a compliant application? Of course it can. But there's only so much infrastructure and other structures, pavement, that can fit in. And in my opinion, they've exceeded that.
And your other comment about the recharge, you're saying that the way that they made the way the calculations they used doesn't apply correctly for the amount of recharge. But when you said there's no recharge, there's obviously some recharge, it's just not at the levels that they're stating it. I mean, obviously there is some recharge that has to happen on the site. It can't be that nothing is going to be recharged. Is that correct? Or
You mean under developed conditions, under proposed conditions?
yes.
I think what my actual statement was very close to that, was that they haven't proven that there's any. In the way that DEP require and your own regulations require them to prove it, they have demonstrated zero. Is there any scrap of lawn there that might soak some rainwater in? Sure. Might some water in the stormwater basins that they designed recharge groundwater? That's possible. They just haven't proven it to me.
Okay, and then the last part, you said about, in the regulations, about 2.5 acres per basin. So you're saying on a site like this, they would need over 60 basins in which to do that? If you're saying it's it's almost 150 acres or more?
That's a fair statement. It's a little more complicated than that, because it only deals with the certain portions of like the ground level impervious cover where the pollutants and things are presumed. But yeah, they would need, I mean, the real answer to that hinges upon whether or not you believe that the basin, like Basin F that we showed in Exhibit 8 there, whether or not that's one basin or 10 basins. It's my opinion that it's one basin. It's the DEP's opinion that it's one basin. So yeah, you would need, I mean, this is a big site, quite frankly. I'm not saying you would need exactly 60, but you'd probably need, I don't know, 20, 30, yeah.
Well, obviously, they're going to have some rebuttal. We're going to rely on our experts to mitigate what both of you are talking about, and that's what the board will take into consideration. Thank you for your comment.
No, thank you for the questions. Are there any others from the board?
Well, if there's any other comments from the board, so Mr. Parch, do you want to call your second witness? There was no cross.
Oh, I'm sorry. I assumed those questions.
There was no cross.
Thank you so much for your attention.
You're welcome.
Good evening, Cassie Zabavlu with Earth Justice representing SSJ.
Can you please raise your right hand? Can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Please state your full name and affiliation for the record.
Nicole Gardner. I am a Vineland resident and I'm a member of Sustain SJ.
Nicole, what's your interest in this matter?
As I stated, I am a resident of Vineland.
And you said you're a member of SSJ. How long have you been involved in advocacy on this data center project?
We joined together as a group of local residents back in November when we realized what was going on over at the site, and then we incorporated as a nonprofit in March of this year.
Have you been to the site?
I haven't been to the site, I have driven past the site.
And what have you noticed when you've driven past it?
Cranes, very large walls, very imposing large walls, giant gray box. You can't see much of anything from the road.
What are some of the things that concern you the most about this project?
Our biggest concern around this project have been the unknowns. It's the largest hyperscale data center on the East Coast. It's a lot of new technology or technology that has never been used to this scale. And They want us to believe that they know what they're doing, but every time we hear from them, something has changed. So it doesn't really give us any confidence that they actually know what they're doing.
So would you say, do you trust Data One and the information they've shared thus far in this application?
No.
And why don't you trust them?
The size and scale requires them to be forthcoming with their information, and they just haven't been to this point. The CEO of Data One visited Vineland in January for a town hall, and he brought a lot of information that had loopholes, to be honest. When we pushed back on that information, it changed every time we questioned it. There was a website put up at one point where we could go to visit the steps of this project. That was then taken down. There's an email address we were directed to for frequently asked questions. Those emails frequently went unanswered. They promised to be good community partners, and they have yet to do that to this point.
What are some of the inconsistencies you've seen in this application?
So water is the biggest one. They promised to be a net positive producer of water, and then also asked for 22 million gallons. We heard at the last meeting, it's now 8 million gallons, but that didn't include full operation. There's a 27 million gallon reservoir. That number is just continuing to be all over the place. I'd be interested to hear what they have to say tonight for that number. There's power. Very early on, we heard rumors that this was going to be a 1 gigawatt facility. We were told no by both our mayor and the CEO of Data One. That website that went online and then shortly later went offline said it was going to be 1 gigawatt. It's gone back and forth. As you saw, the objector that was up here earlier mentioned a BPU application of 125 megawatts. There's no confidence that they know how much energy they're actually going to use, and I don't have confidence as a Vineland resident that my energy is going to be protected once they're actually fully up to operating. The last one would be the CO2 emissions from Bloom. Those numbers are all over the place, and as was mentioned at the last meeting, this site is 400% larger than their next biggest site. And so between water and energy and the CO2 emissions coming from this site alone, I have no confidence in any of the experts that Data One has presented.
So what can Data One do to address your concerns? How can they give you that confidence?
That would be very difficult at this point, but I think 2 moves towards that could be a true independent environmental impact study from an actual independent company that has no relation to Northeast Precast Consulting or Data One. That report needs to include everything that was addressed in the Vineland Environmental Commission statement, everything that was addressed in the Pannoni report that was provided to the planning board, and every single question that came up August 5th and at this meeting that has not been addressed yet. I'm sorry, there's one more thing. Community benefits program. That would be to come to the table with a program, something like this, a giant town hall, and actually talk to residents of Vineland, not our mayor, not city council, not those interested in owning Nebbia's stock. Talk to actual Vineland residents about what we want and how we want our tax money to be spent.
And what would you ask of your planning board today?
At this point, this is a no vote for you. There has been too much information presented on August 5th and today that is bringing up too many additional questions, and it would be irresponsible for you to vote anything other than no. There's potentially a way to move forward with this company, but they have to actually come to the table and answer all of our questions before they do that. And you owe every single Vineland resident, you owe it to every single Vineland resident to have all of the information to make an informed decision before you vote anything other than no for this site.
Thank you, Nicole. That's all I have.
Hold on.
No question.
Okay, no questions on it. Ms. Bellevue or Mr. Parks, do you have any other witnesses this evening? Okay. And I'm going to ask this, even though I asked last time, are there any other attorneys in the audience representing any objectors? Okay. With that, I'm going to ask the applicant if they have any rebuttal witnesses.
I do, Mr. Malinsky. I'm going to call Tim Ruga first.
Mr. Ruga, you understand you're still under oath with regard to this application from when you were sworn in at the last hearing?
I do.
Okay. And I'm assuming since the last hearing, your licenses or your certifications are still in good standing?
Yes, sir.
Okay, thank you. Mr. Ruga, you heard the testimony of Mr. Emerson, and I know during that testimony you had the ability to peruse the review reports that he had prepared. Let's talk about that a little bit. He went through, gave us a lot of information, and let's just start with Basin S not complying with the rules and indicating that it doesn't comply because of the 2.5 acre area, drainage area. What do you think about that? Do you agree with that?
No, I don't.
And why don't you agree with that?
Because the rules allow for alternative methodologies, and we think in this case it is appropriate to do 2.5 acres in the small scale, immediately adjacent water quality basins that we've designed. And so that is what we have for recharge in the front. That's what we have in a number of the basins, but Basin S is the question. And that allows for distribution of the water throughout the basin. It doesn't concentrate it anywhere, which is what we believe is the intent of the regulation, and we've met that.
Okay. Let's start a little bit. I was on page 2 of my notes there. Let's go back to the beginning. We'll get to this Basin S and the recharge issue because I have a lot of questions about that as well. The first thing that got brought up was soil testing.
Yes.
With the soil testing, with the number of the locations, not related to anything that we're doing on site with regard to the stormwater system. Is that accurate?
No, no. The soil testing is required for the recharge basin. That's by Lincoln Avenue, and we did have sufficient borings in that basin or close enough to it as required by the regulations. The other basins do not require soil testing because they're all bioretention basins, and we have complied with the regulations.
And speaking of Basin A through H being in phase 1 of this project, that stormwater system was previously reviewed?
Yes, it was.
And it was approved?
Twice.
And it was approved to be in accordance with NJDEP stormwater regulations?
Yes.
Okay. Let's see. What about the issue with the soil borings not being the proper depth?
So, I'm not sure what's being referred to there. We did advance the soil borings as required by the regulation in the area of the infiltration basin. Not all of the other ones were, but we had sufficient soil borings of depth in that area.
Okay. Now, you mentioned Basin S with and I believe the term that Mr. Emerson used was soil separators. And he indicates that DEP says can't do it that way. Do you agree with that?
No.
And why don't you agree with that?
Because there's nothing in the regulation or the best management practice manual that says that. As far as any other documents that were produced, I have not seen those, but I don't agree with that. I don't believe there's any technical reason for it.
But the technical regulations themselves do not say that.
Correct.
Okay. Let's talk a little bit about water quality. He brought up 2 discharge points, and somehow that's an issue. What does that even mean?
Well, he's talking about two discharge points, is one being Lincoln Avenue and the other one being towards Northeast Precast, as he did indicate. And it's simply saying that we have got two primary areas where flow goes off the site. There had been some other minor ones on the site that we currently have no water going off, but the two that we are using are the two primary discharge points that we always had.
And does that comply with the regulations?
Yes. It complies because we meet all the requirements for discharge at those locations.
Okay. So the stormwater system is not hurting anybody downstream?
No.
Okay. Now, one thing that was brought up was the hydrograph. Must use the Delmarva unit hydrograph. What do you think about that?
So we went and looked at that issue. In the last meeting, I represented that we use the SDS hydrograph because it is, in my experience, more conservative. And in recomputing our numbers since the last meeting, we found it indeed to be more conservative in terms of flow in the pipes. That being so, we have no problem going to Delmarva. In recomputing it, I can tell you that it affected nothing with the basins. The basin by Lincoln Avenue with the recharge, it affects not the basin itself or the outlet structure. For the bioretention basins on the site, none of their sizes changed or anything about them, but using the Delmarva unit hydrograph would require that we reduce the hydraulic controls in their outlet structures. That would be the orifices and the weirs, and make them a little bit smaller because of the smaller flows that the Delmarva unit hydrograph predicts. And so we have actually made those adjustments in our calculations, and we defer to the city engineer. If he wishes us to go and use the Delmarva unit hydrograph, we're happy to do that. And we'll revise our outlet structures accordingly.
Okay. So another thing that was brought up was the utilization of the aerial survey for topography.
Yes.
Okay. Let's talk about that a little bit, because I don't think Mr. Emerson disagreed with you that utilization of the aerial is a good thing to do. But he indicated that this particular project, it wasn't done correctly. Is that true?
It's a little difficult to know what he's referring to because there's no substance given to that. But we believe that we used it correctly. And as far as on-site verification, of course, we were out there constantly, so we did understand the conditions that existed on-site.
So what does it mean when there would be an inaccurate characterization of the land cover at the site?
I'm not sure. He may indicate that we're using something that didn't actually exist.
And are we?
No.
Okay. Let's talk a little bit about groundwater mounding. And there was indication made about the utilization of a number of 150 feet versus 75 feet. Can you explain that a little bit?
Yes, he's talking about the guidance that is given for recharge, or not recharge, mounding calculations in the best management practice manual. And in fact, it does give that guidance, but it also allows for alternative methodology, as I mentioned before. And that's what we've used because we have a lot of hydrogeologic information in this area, including, most notably, Vineland Well 17, immediately adjacent to this site, in which the New Jersey Geological Survey themselves used a saturated thickness of 200 feet. As well, they used a hydraulic conductivity of 80 feet per day. We didn't bother increasing the hydraulic conductivity for this mounding analysis. We just kept the state guidance of and just a factor times the vertical, which is not realistic at all. But we use that, and we use a saturated thickness of less than the 200 feet, only 150, and found that the mounding was within what it needed to be. If we actually adjusted those numbers to what they should be based on the transmissivity of what was measured right next door, our mounding would probably be on the order of about 2 to 3 feet.
As opposed to what?
As opposed to 9.2 feet.
Okay. So, are you in accordance with the rules, doing it the way you did it?
Yes.
Okay. And again, this has been submitted and reviewed?
Correct.
Okay.
And I just say that we've been, I think, that was since 2024. So we have 2 approvals on that.
Okay.
Without an objection.
Without an objection. Let's talk a little bit about groundwater recharge. There's an obligation, according to Mr. Emerson, to maintain the amount of water for recharge to replenish the aquifers to what's in a pre-development stage and post-development stage. Let's talk about that a little bit with regard to this site. Are we providing recharge on this site?
Yes.
And how did you determine how much recharge we had to supply on this site?
So we did apply the recharge spreadsheet in accordance with the methodology.
Okay.
But I can explain further if you like.
Absolutely.
Yeah, so what I heard was that the issue that we ignored was the fact that we've got depressions on the site that don't allow for water to flow off the site, and therefore all of that water would recharge. But in fact, that would be true, and I would agree with those comments if these were sand pits. If they were sand pits on the site, then all of that water would be captured, it would all be forced to recharge, and we would have to account for that. But that isn't the case. This is Clayville, and the reason why it's Clayville is because these were clay pits. For more than 160 years, there were clay pits on this site, and the water that went into those depressions did not go into the ground more than what we said they did, because we went out and tested those soils and found out what those soils were, how much they would transmit, and was very low. They were mostly C and D soils that we found when we reclassified the pits. And as a result, the application of the spreadsheet, the way we use it, is accurate, and we stand by what we did.
There was talk about 60 acres providing 0 recharge on the site. Is that accurate? There was one of the exhibits.
Or it might have been the other way around, but yeah.
Not 60 acres.
We actually looked at all the site with the groundwater recharge spreadsheet. Mm-hmm. So I'm not sure what was meant by that.
Okay, and that's that GSR 32?
Correct.
And that is appropriate to use here?
Yes, it is.
Okay. Let's talk about the 2 figures that you used for recharge, or indicated that you used for recharge, the 5.5 inches per year, and then the 13 inches per year. Tell me what the difference is and what, why both of those appear in the report.
So the 5.5 inches is what was the result of that spreadsheet. That's what we came out with when we computed according to the NJDEP methodology using the soils that cover the site. And some of those were reclassified soils, as I mentioned just a moment ago. With that methodology, when you figure it all out, that's what it comes down to. The 13 inches of recharge is a very different number. That's a number that we use to rough calibrate a groundwater model that was used to come up with seasonal high groundwater from our 2 years of well data that we had. And that number was applied to the surface of the ground over a very wide area, not just the site, but it was applied over the entire groundwater shed, which includes, I don't know, I'd have to go look, but maybe 50 times the area of the site. It's a big area. And so you can imagine that when you have rainfall falling on the land, in some areas you're going to have sandy soils, you're going to get a lot of recharge. Other areas you'll have clay, like we did over the half of this site, and you're gonna get essentially no recharge, or very little. And you put all of that together over this groundwater shed, it ends up being not 5.5 inches, but 13 inches on average. And for our groundwater model, we didn't bother differentiating because groundwater acts more of an integrator. We just applied it to the entire groundwater watershed. And in fact, when you look at the other number that was referenced, the regional number of 13 inches, that again was a very large, a gross number that was taken over a big area that was computed by DEP by looking at rainfall and comparing it with how much water flows out of the streams in base flow. That's how they came up with that. But it doesn't look at something as finite as this site. And in order to come up with those recharge numbers, we had to use the spreadsheet as we did.
And in your opinion, did you use the spreadsheet properly?
Yes.
Okay. There was some comments made about the water use that you had talked about at our last hearing, about the worst case scenario of 27 million gallons and then 8 million on average, and how somehow we're not giving back any the groundwater recharge. That's not accurate, is it?
No, we disagree entirely with the groundwater recharge part of that. We believe we're giving back what was there before. And in addition, when you look at the double takeaway that was mentioned, that I believe is an unfair comment because when you pump water for your average farm, you're pumping it onto crops and much of that water is lost to evapotranspiration. That's similar to what we're doing. So this is a permitted use of water to be able to use it for evaporative purposes, and it's commonly done in Vineland.
So the entirety of your stormwater basin design, it was reviewed previously a couple of times, at least the front half of it was, and approved.
Yes.
And now the entirety of it, for the back part of it, is being reviewed again. And you have received a review letter on that from the city of Vineland.
Yes.
And is there anything in that review letter that you can't comply with?
No.
Okay. So is it your opinion that even notwithstanding Mr. Emerson's testimony, that your stormwater design is in accordance with the DEP rules and regulations required for this project?
Yes, absolutely.
Thank you very much, Mr. Ruda. That's all I got.
Mr. Village, are you done?
Yes.
Yeah. Mr. Wendt, do you have any questions for this witness? Mr. Parks, do you have any additional questions for this witness?
Yes. So, Mr. Ruda, last time you weren't feeling very well. I hope you're feeling a little better this time.
Thank you. Yes, I am.
Great. So, I want to start by asking you about reviews and approvals. Has the DEP reviewed or approved this application?
I'm sorry, can you repeat that?
I want to start by asking you about review and approvals. Has the DEP reviewed or approved this application?
No, sir.
Are you aware that at NJAC 718-5.2, any alternative methodology for complying with the green infrastructure requirements has to be approved by DEP and has to qualify as green infrastructure?
Yes.
You just stated that you were using an alternative methodology for this basin S that we talked about. Is that correct?
Yes, I am.
And that had to be reviewed by DEP per the regulation, as you said, correct?
It will have to, yes, if they choose to. Correct.
And it is your statement that this does comply in spite of the overlay between the example by DEP and the basin S, which looked almost exactly the same. Am I understanding that correctly?
Yes, it does comply with the regulations and the best management practice manual.
Which requires approval by DEP.
Which requires what?
Approval by DEP.
Yes, if they choose to. Yeah.
So you also made a statement regarding the approval twice. The plan has changed multiple times since 2024, isn't that correct?
Correct.
And so is it your statement that prior approvals continue for future approvals despite changes?
Yes. And I'll give you the reason. That is because in 2024 we had basins in the same area and doing basically the same thing as we have right now along Lincoln Avenue. And I was referring to that basin in particular, not the ones in the back. And then in 2025, that basin was approved identically as it is now. It was built following that approval.
And is that basin also an alternative methodology?
In terms of the 150 feet, yes.
And it has not been reviewed by DEP, is that correct?
To my knowledge, no.
So I'd also like to ask another question about the 150 versus 75 feet. The DEP itself created the maximum of 75 feet, as we heard from Mr. Emerson, is that right?
Yeah, that's what's written in the manual, yes.
And it's your opinion that despite DEP, the approving authority, creating this 75-foot maximum requirement, it's okay to go twice that?
Yes, exactly.
Okay. And then I guess I just want to clarify towards the end here. I think there have been a couple of maybe misunderstandings about the question that I asked to Dr. Emerson, and apologies, folks, I should have said doctor from the beginning. Dr. Emerson stated that the recharge there was zero recharge being provided in a state-approved manner. Not that there was zero recharge being provided. I think we've heard a couple of times that it was a statement that there was zero recharge being provided. Just to be clear, it's your opinion that the recharge is being provided in a state-approved manner.
It is our opinion, yes.
And DEP has not reviewed this application.
That's right.
Okay.
Good evening, Castellano here again for SSJ. Mr. Ruga, I can't remember, were you one of the experts that could answer some questions about the closed loop system?
No.
Ah, okay. Then never mind. No further questions, thank you.
Any questions from the board?
I'm gonna just have a couple that are a lot less technical. Maybe some of the engineers that I got sitting down here to my left will have some more technical, but we are gonna go to our technical staff because what we're seeing here is the duly qualified expert saying one thing, another duly qualified expert saying another thing. This is not uncommon when it comes to our planning matters, which also is, which I just heard, is not uncommon for one of our meetings or one of our applications when there is something that needs to be approved that we allow to go back to our staff and work with the applicant to approve. Changes come in all the time with applications, this one especially because it's been so many. So there have been changes, and a lot of times we'll go back to our professionals to say, we want to make sure that it agrees with the Vineland codes. So in a couple of those questions, oh, and I'm sorry, I did have one for Mr. Ruga. It was mentioned a couple of times about overflow going to the northeast precast. Now, I know there's some common ownership, we understand that, but is there overflow from this site going to the other site?
Yes, there is, and there historically was. And so when you look at the amount that historically flowed to northeast, that's part of the existing condition. And there's certain restrictions as to rate that have to be observed for that, and we did meet those requirements.
Okay. So, Mr. Headley, so there was testimony about the soil testing only needed to be in the recharge basin. Is that accurate? Is that?
So the soil testing does have to follow Chapter 12 of the NJ DMP manual. Was a comment in my report, and I believe Mr. Ruga did agree to that comment. I think it's subsection, I want to say 2B with respect to non-infiltration BMPs with a required distance for seasonal high, required distance between the bottom of the basin and seasonal high water table, which bioinfiltrations would classify as. So the short answer, or the long answer, I guess, to your question is, there is a soil testing requirement for non-infiltration BMPs in accordance with Chapter 12 that will have to be met, as noted in my comment in the review report.
The depth of the basin, the depth of the soil warrant, those have been sufficient to our regulations or DEP's regulation?
Off the top of my head, I don't remember exactly which depth would be referred to, but they would have to meet the same regulations, Chapter 12 of the soil testing criteria, which it is pretty explicit as to where the testing has to be.
So in this application or any application, they're going to bring it in, they're going to give it to our staff to review that if it meets what you would believe would meet our regulations and the DEP regulations before it would end up going to DEP and get their approval. In this, would it have gone to DEP at this point of the application process normally?
Normally, we don't see a lot of alternative methods, so normally no. It doesn't go to the DEP, with the exception of if it's required an additional DEP permit. When you add the alternative method, that does have to be sent to the DEP. The DEP regulations don't provide a lot of guidance as to when that is supposed to happen, whether it's prior to your approval or as in, I'll call it as a secondary review. So at this time, the city puts the onus on the applicant to submit that to the DEP for review.
So what would happen theoretically if the city has reviewed them, given them some idea of approval that they meet them, but DEP does not? What happens then?
They would have to, work with the DEP to address any comments if they have comments on their alternative methods. And then it could potentially require a revision or change to the stormwater design itself, depending on what the DEP says.
But as of this point, the review that your staff has done doesn't see the issues with the recharge issues or the ground or the stormwater management.
So as of right now, with respect to water quantity, which is one of the aspects that was touched upon, we feel it does meet because it does meet, I think it's criteria A, which is a reduction in runoff rate at every pre-discharge point. With recharge, we did have a couple questions in our report just for clarity, but that the applicant has agreed to provide that to us. And then with respect to water quality, that would be met by the bioinfiltration basins primarily.
There was a question about the topography of that area. Obviously, we don't see a lot of that. So does that change the way you review it? Because it's different?
You mean like having the depressions and stuff like that? So yeah, we're required to, when there is depressions or areas that essentially don't have an outflow, it's required to be accounted for in the pre-developed existing hydrograph calculation, which I believe it was with Mr.
Yes.
Mr. Menz.
The outfall going to North Precast have reduced it. Have you retained some of the water so like at peak flow for 100-year storm, whatever. Have you reduced the maximum quantity that's being that's falling into the Northeast Precast section?
Yeah, we have reduced the rates at least to meet the state requirements. The quantities haven't been dealt with specifically, but we believe it's going to be fine. It certainly meets the regulations.
Okay, and also in regard, where are we in building the bioretention and other basins? Have they begun right at this time?
No, not yet.
Not yet, because you will be obligated to do, a test, to do a boring and testing and
yes.
perk rates after they have to have a perk test, percolation rate test after all the basins are built.
Yes, we understand.
Yes, I'm letting everyone know that.
Yeah.
And it has to be like from our consultant, Panoni Associates, for an example, or whoever the city wishes to go to. Each basin retention, bioretention will have to be tested after it's built.
Each infiltration basin.
Correct, each infiltration.
Each infiltration basin, that's a city ordinance. At post-construction, where we require 3 things. For all basins, we require a certification from the engineer that it was built in accordance with the design plan. And then also, we require an as-built survey of the basin that we check to ensure it was also built size, weir configuration. And then for infiltration basins, we do require an as-built permeability test to ensure that it is in compliance with any permeability rate that was utilized in the initial design.
And what about the bioretention basins?
Bioretentions have an under drain, so technically they don't have an infiltration that is used in the calculation, so they would only require the certification and the as-built. They are still required to fully drain within 72 hours in accordance with our and the state regulations. That's how, but they don't actually use infiltration as part of the groundwater recharge.
Right, it's just that I was on a project, still am, where we actually did a test. But that was, the developer asked for that.
Yeah.
So
Yeah, usually the developer will provide us the infiltration, as-built infiltration rate. We wouldn't, that's how typically that's provided by either the contractor or their engineer post-construction.
Right, thank you, Chair.
Any other comments from board members? So, Mr. Fraser and audience, I think at this time we're going to take a very short break and we'll be back and we'll reconvene the meeting at 8:05. So we'll be back in just a few minutes.
Yo, Neptards, what up?
One more time, Zach. What was that?
Yo, Neptards, what up?
8:06, we are calling the meeting back to order.
Mr. Freeland, you want to call your next rebuttal witness?
Yes, thank you, Mr. Malinsky. Call Craig Rainkamp.
Thank you. Mr. Rainkamp, can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth this evening?
I do.
Okay. Before we get started, as a housekeeping item, I'm going to mark into evidence as applicant's exhibit A8. It's an August 17, 2026 email with the following attachments. Public notice packet sent to property owners within 200 feet. Deputy clerk affidavit of mailing regarding the public notice, and this is all related to the zoning change from 2022. Email of June 16, 2022 from clerk's office to relevant parties, including the county planning board, Matt Bazarski, director of county planning. The attachment to the June 16th email being the adopted ordinance, the read receipt confirming Mr. Bazarski's receipt of the adopted ordinance, the zoning officer determination as to use correspondence dated February 21st, 2024, the 2018 reexamination report, the 2020 amendment to the land use element. I'm going to mark as A9. It is an email from Richard Francetti, dated Thursday, May 12, 2022, to all the surrounding clerks with the adjoining letter dated May 12, 2022, which was the pre-notice.
Mr. Fralinger.
Yes, thank you, Mr. Vice Chairman. Mr. Rainkamp, what's your profession?
I am a professional planner. I've been in the field 45 years, licensed in New Jersey for 36 years, licensed currently valid and continuously valid through that period.
Is your license in good standing in New Jersey?
It is.
And you indicated how long you've been practicing professional planning?
45 years.
All of that time in New Jersey?
No, 36 years with a license in New Jersey, originally based in Philadelphia.
And with your New Jersey practice, what is it that you do? You do master plan work? You do redevelopment work? What is it?
I did master plan work earlier in my career. For the last probably 15, 20 years, I primarily worked with landowners seeking zoning changes, use variances, developers, the private sector, if you will, in applications before boards.
Okay. You're familiar with re-exams, amendments to land use elements, things of that nature?
I am. I was a vice president of our professional association for 8 years, qualified over 100 trials in New Jersey, 4 states, and 3 federal districts. So I've worked with those documents and issues quite a lot.
So I assume you've testified in front of land use boards before?
I have. In fact, over the years, I have been here in Vineland, although it's been a few years.
And during that testimony, have you been qualified as an expert?
Yes, at least 2 or 3 times a week for the last 36 years.
As an expert in professional planning?
Yes.
Okay. Thank you, Mr. Rainkamp. And also Mr. Rainkamp is an expert in professional planning.
Any objection? No objection.
Thank you.
Okay. Mr. Rainkamp, let's just jump right into it. You received a report from Peter Steck, did you not?
I did.
And did you have an opportunity to review that report?
I have.
Okay. Now, in that report, one of the things that Mr. Steck goes through is this ordinance 2022-44 and how it all came about. It was an ordinance that changed zoning, and it went through a referral process from council to planning, and then from planning back to council before it was adopted.
Yes.
Are you familiar with all of that?
Yes, that's the usual process.
Okay. And with that, with the referral from council to planning, what did planning do when they received that referral?
Well, let me be specific about Mr. Steck's objection. And that is that the consistency review conducted by the planning board mentioned the reexamination report. There's a case out of Ship Bottom that I was an expert in that found that you can't do your consistency review specifically to a reexamination report. A reexamination report, as you guys and ladies are aware of, is your effort to look at the master plan, think about it, talk about things that should change, but it's not itself part of the master plan. You have to take another step that you did, and we'll talk about that in a minute. So it's improper to do a consistency review using a reexamination report as the benchmark. And that's what Mr. Steck identified. He saw re-exam in the consistency review adopted by the planning board and jumped to a conclusion that that was the benchmark that we used.
Okay. Well, let's break that down a little bit. Because he saw that and he jumped to the conclusion it was a benchmark. And that was in Planning Board Resolution 6509?
It was.
Okay.
And the specific mention of the reexamination report is the first whereas on the second page.
Mr. Malinsky, I have 6509, like this. I got an extra copy or two of Mr. Wendt, and other council doesn't have it. Okay.
I'll mark this as A10.
You want? Let's go through 6509 a little bit.
Yes.
Tell me what you see in it.
Well, there are a series of whereases on the first page that talk about planning policies in the city, that then led to that statement on the second page, and then a conclusion that it was consistent and recommended as an action that the governing body should take.
Okay. Is there anything that jumps out in the resolution which is, helpful to a consistency review?
Yes, there are a number of paragraphs in which Ms. Hicks provides planning testimony to the planning board. And while she doesn't specifically lay out the foundation, it's important that the board was aware of the work that it already had done. A 2017 redevelopment plan that covered this area, the 2018 reexamination report that Ms. Hicks simply identified as the source of the original policy to think about adding industrial lands, additional lands to the city. There was then the January 2020 land use element amendment that specifically effectuated changes to the master plan, supporting the expansion of industrial lands, ending split zoning, adding smaller lots to larger parcels, and essentially laying the foundation for the planning testimony that Ms. Hicks provided to the planning board, leading to the 2022 consistency review. And I would say the second and third from the bottom, whereas is on page 1, are drawn literally from the land use element amendment. You could wish from a drafting perspective at the end of Ms. Hicks' testimony, the author of the resolution put comma, as supported by the land use element amendment, that would have certainly clarified it, but it's absolutely clear that the language that Ms. Hicks used in her testimony comes directly from that document.
Okay, let's talk a little bit about that, because when the consistency review, what is the consistency review? What are you reviewing it to be consistent with?
It is the obligation of the master plan, of the planning board, to compare the new policy initiative that the governing body is creating by the ordinance to the master plan of the community. That master plan can consist of a variety of elements, the housing element, open space element, a land use element amendment as was adopted in 2022. So the master plan can come in pieces, and it's the planning board's job to integrate all of those pieces, compare it to the new policy, identify any departures from their previous planning, and then with respect to those departures, identify whether they're substantial or not, and then in addition to that is the obligation. They're then allowed to express an opinion as to what should happen, which is what they did both of those here, and their opinion was that it should be adopted.
Okay. So, did you have an opportunity to review what you referenced as the amendment to the land use element?
I did.
Okay. So in this case,
And that was included in A8, as I understood the marking.
I don't believe the amendment was in A8.
Yes, it was.
The amendment to the land use element?
Yes, it was.
I was listening.
A8 includes the 2018 reexamination report and the 2020 amendment to the land use element.
Fantastic. Okay, thank you very much. All right. So in Mr. Steck's report, and correct me if I'm wrong, he indicates that in his opinion it was inconsistent with the 2008 master plan. But I didn't read anything in his report about anything after the 2008 master plan.
Correct.
And what had to happen in his review?
Well, obviously, you would have to look at the master plan as it existed as of the date of the consistency review, which would have included the land use amendment.
So in other words, it would have been the master plan as amended?
Correct.
Okay. So you reviewed the master plan here, the 2008 master plan that Mr. Steck referred to?
Yes.
And you reviewed the 2018 re-exam report?
I did.
And you reviewed the 2020 amendment to the land use?
Yes.
Okay. And then in 2022 is when this consistency review occurs?
Yes.
So at that particular point in time, it's the planning board taking a look at where the current city policy is as regards the 2008 master plan as it was amended in 2020 with initiatives from the 2018 re-exam.
The 2018 re-exam identified the issue of additional industrial space being needed, ending split lot zoning, adding peripheral parcels to larger tracts.
Okay.
Those were all identified as things the city should think about. They were then executed through the land use element amendment.
Okay. So the land use element amendment, let's talk about that a little bit, about what that did. How did that change policy in the city or clarify policy in the city?
To a very large degree, it took the policy initiative of the land use element and turned it into a master plan amendment. It didn't strike off in a new direction. It was simply implementing the ideas that had been identified and put it in proper form to be an amendment to the master plan. It then went around the city and identified areas where there was split lot zoning, areas where there were redevelopment opportunities, where adjacent parcels could be brought into the industrial district, and it recommended specific zoning changes related to the parcels that the city was aware of in 2020.
Okay, so was this particular parcel, what we're talking about here, let's go back a little bit. Let's indicate what it is that we're talking about here. Are we talking about the entirety of the property that the data center is being constructed on?
Yes.
No.
After the fact in the amendment, yes.
Okay, we're talking about a 14 and a half acre.
Addition to it, yes. Right.
Correct. A 14 and a half acre addition to where the data center is currently being constructed.
Correct.
Okay, so the data center property was zoned IB and this 14 and a half acres wasn't.
Correct.
That's what we're all talking about.
Correct.
Okay, and in 2022 is when the ordinance was adopted that changed that zone.
Correct.
Okay, so the 14 and a half acres is what that ordinance dealt with, what the consistency review dealt with.
Correct.
Okay, so the 2020 land use element, it had in it some properties that the city said, we need to change these to industrial. Is that correct?
Correct.
All right. Was the property, the 14 and a half acres that we're talking about here in block 7503, was that part of it?
It was not. The core property that becomes this application eventually was at the time in an existing industrial use and was therefore not considered or reviewed by the city as something that should be expanded or looked at or changed.
Okay. Is that fatal to the analysis?
No.
And why not?
Because all the consistency review was doing, as Ms. Hicks testified, was taking the policies established in the land use element amendment and applying them to a new factual situation.
Okay.
And coming up to the conclusion that it was consistent with the overall policies.
And the overall policies, let's talk about that a little bit. What was it that the land use element was looking for with regard to reclassification of industrial properties?
And less reclassification than boundary moving. This was not creating a new zone somewhere, it was simply dealing with where the line should be between uses. And it made the determination that additional industrial opportunities were beneficial for the city and should be added, and then looked for opportunities for split lot zone or small lots near larger lots to consolidate into larger development parcels for redevelopment.
Was there a mention of it being near 55 interchange?
For this particular site, yes.
And was that one of the policies from 2008 being an initiative in 2018 re-exam that goes into the 2020 land use element to find more opportunities for industrial and take a look at the interchange areas?
It's a thread, but the initial desire to expand industrial was not limited to 55. Related to this parcel, that was an important consideration. But there were other parcels that were expanded that were not necessarily connected to an interchange.
Okay, all right. So your review of this, do you find inconsistencies between what was done and the master plan as amended?
Well, the inconsistency was identified by the planning board as the change in zoning from residential or agriculture to IB. So that was the only inconsistency. There was no other inconsistency for the planning board to find that it needed to make a decision about.
And from a professional planning perspective, what is it that you're looking for when you see a resolution like that?
The provision of testimony as Ms. Hicks provided, identifying the planning policies of the city and their relationship to the zone change that's being recommended by the governing body or being considered by the governing body.
Okay, so it's not appropriate to rely upon a re-exam report, but you also can't disregard the re-exam report.
It's certainly not illegal to say that a re-examination report was the time in history in which the city started thinking about an issue. The important thing is that they then implemented it through an amendment to the master plan.
Okay, and when they implemented it through that amendment to the master plan, and that, what does that do as far as this resolution is concerned? The implementation
This
of
resolution relies on the planning policies of the city to determine that this was an appropriate direction to go in terms of the zoning change, consistent with the overall planning policies of the city.
Okay, so the resolution that carried forward that policy?
Yes.
Okay. And the resolution was formally adopted by the planning board?
Yes.
And it was sent back to council?
That would be my understanding, yes.
Okay. And ordinance 2022-44 is the ordinance that came out of that, is that correct?
Yes, that was the governing body adopting the zoning change that had been referred to the planning board.
From a professional planning perspective, did you see any issues with that ordinance?
No, the governing body accepted the recommendation of the planning board. Further, there's a whereas section that sets forth the planning policies, so the governing body clearly understood what was going on. So it was a clear expression of what they were accomplishing. It was an acceptance of the planning board's recommendation, and then implementation.
So from a professional planning point of view, there would have been no reason to do inconsistency findings?
No, the only inconsistency was obvious on the face of the ordinance itself. Right. It was a zone change going from residential and agriculture to industrial IB.
So you don't find from a planning perspective any substantial deviations in the planning process or in the procedural process for the adopting that ordinance?
Yeah, neither procedurally nor substantively do I see an error or a mistake.
So you don't agree then with Mr. Speck that the 2022-44, the ordinance was inconsistent with the master plan as amended?
No. The principle that he set forth that a re-exam can't be the benchmark by which one does a consistency, I agree with completely. But the implementation here clearly shows a planning history of doing it correctly and bringing that information before the board rendered a decision.
Now, after the ordinance was adopted, you talked to me at length a little bit. Well, I say at length. You tend to go on sometimes. But you talked to me about the June 2023 amendment to the redevelopment plan.
Yes.
And what significance does that have in this whole process?
It amended the original 2017 redevelopment plan, reflecting the land area that had been adopted in terms of zoning. So the entirety of the parcel, which is the application, is included by the 2023 redevelopment plan amendment in the redevelopment plan.
So from a professional planning point of view, what does that tell you?
Well, two things. It's confirmatory in that the city did it twice, so they clearly knew what they were doing. But more importantly, this is an application under a redevelopment plan, and while the redevelopment plan, in this case, looks back to the permitted uses in the zoning district, it's still an application under the redevelopment plan. It would have been awkward had part of the application been outside of the redevelopment plan area, even though it might have been consistent with zoning. So this brought it all together as one piece under the redevelopment plan.
Okay. Mr. Malinsky, the June 2023 redevelopment plan?
I'll mark this as A11.
Okay.
Okay, with regard now to the ordinance and to the referral resolution that the ordinance was based on, do you find, is it your opinion, that the change in zoning was consistent with the master plan as amended?
As a matter of fact, yes. So separate and apart from the process, yes, it absolutely was from a planning perspective.
Okay. Let's move on a little bit. Because Mr. Steck also attacks some other things with regard to the application. He attacks the fact of it being a permitted use, that the data center is a permitted use in the IB zone.
Yes,
Now,
he has two justifications for that opinion. One is that it's his opinion that it's not manufacturing. And secondly, then, that if it's not manufacturing, this is an ordinance that you have to be listed as a specific use, and he didn't see data center as a specific use. So those were his two arguments.
all right, well, let's break them down a little bit. Because as part of this, did you review a February 21, 2024 letter from the zoning officer?
Yes,
And
authored by Patrick Finley, February 21st, 2024.
And in that letter, what did Mr. Finley indicate about the use status of a data center in the IB zone?
I just wanted to double check it. He said data center. Yes, he found that this is a permitted use in the district.
Okay. So the argument about manufacturing, let's talk about that with Mr. Steck. He argues that it's not manufacturing, and therefore, I guess the argument stops there.
In his presentation, yes.
And
my analysis, no.
What would be your analysis?
Well, first let me say that the zoning officer's determination, and this is for the lawyers to deal with, is binding on the board. That if someone were to appeal this letter, it would be an appeal to the zoning board. In some municipalities, you go from the zoning board to the governing body. In most municipalities, you go straight to court. But in no circumstance does that process come back to the planning board to determine whether or not the zoning officer is correct. So we're debating how many angels can be on the head of a pin, essentially, because this letter is already binding in terms of this application. But nevertheless, going forward, it's important to understand that within this redevelopment plan that then refers back to the zoning code and the permitted uses in the districts underlying the redevelopment plan, that the IB is a district that builds on other districts. This is what the planners call a cumulative zoning. So in the IB, you can do all of the uses listed in IB, but you can also do all of the uses listed in I1, and you can also do all of the uses with some minor exceptions in the B3, the business zone. And when you go to the B3, that brings all of the uses that are in the B1 with some minor exceptions. So all of the potential uses to review for whether or not a use is permitted in the redevelopment plan is in the IB, the I1, the B3, and the B1, not just the I1 in terms of the structure of your ordinance. And I found several that I think fit what a data center actually is.
Well, let's talk about that a little bit, because I believe it was Mr. Steck's opinion in his report, at least that I reviewed, that because the words data center didn't appear in the ordinance, then it was not a permitted use and therefore it was a prohibited use.
Right.
Is that the way Vineland's ordinance is set up?
It's not, nor is it how any ordinance is set up, frankly. I view computers as a tool, and it doesn't matter how many of them you have, it's still a tool. I can use a hammer to be a metal worker, I can use a hammer to be a carpenter, I can use a hammer to be an artist. The tool doesn't define the use. The use is defined by the business. What are you doing? What are you making? What are you selling? What are your services? What is it? So I would never expect to find data center listed as a use. But data center is in virtually every major law firm. It's in every hospital system. If you're watching TV that don't have rabbit ears, all of those programs are being spooled to you by a data center. So data centers are all around us. This is bigger than some other data centers, but in terms of the way as planners deal with it as a use, the data center isn't the use. The use is what the data center is being used to accomplish.
Okay. So in the IB zone, you've looked at some of these things. I call them categories or buckets or classes or something like that. I know you like to correct me when I do that, but
that's fine.
But
I won't do that tonight.
But just give us some examples of things that are not like specific enumerated things like that say data center, but are classes of uses.
Well, I mean, the first one to start off is the business office, which is in the B1 district, and this provides service for a fee. Most of the data center work that I've done over the last decade has been data centers that are part of uses that are selling some sort of service. Here we know that Data One is the owner of the facility. There's an intermediary that owns the computers, but essentially you have an end user, in this case Microsoft, who's buying the time and computational power. And Microsoft provides an array of services. Game Pass, if your kids have an Xbox. OneDrive, if you're saving documents. They're boosting their Bing search functions with Copilot, more of a giving you the answer rather than simply sending you the references. There's content help in creation in Microsoft 365. So they're using their computational power to provide additional services within the bundle of businesses and personal services that corporation is already selling. That they're using a larger building to do it doesn't change the nature of that being a traditional business use, selling services ultimately to end users.
Anything else that you find?
Well, going in a more old-fashioned direction in the industrial district, you have publishing. And publishing doesn't require or be limited to simply paper. So if your view of what's happening in the data center is the gathering of information and disseminating, that's exactly what publishing is. So it could fit in that category as well. And as in any industrial district, you have research and development. Anybody working on large language models understand that that's a research and development exercise. You're constantly tweaking it. You've got armies of people working on making it better and advancing it. All of that is traditional research. So I don't think it's very hard to find a category to fit it within Vineland zoning ordinance.
And it could fall within several different categories.
It could. My favorite is business office. That's the one I've used in other municipalities doing larger format data centers. I mean, certainly if you get into the multi-million square foot things in the desert that have one user, that's a different universe. That's not what we're talking about. So to me, this is just another tool. It's being used by Microsoft in its normal provision of services.
Okay. So what we're talking about from professional planning and zoning classification standpoint, it's not the label, it's not the name. And I think you and I had a conversation earlier where you said, I don't care if you call it a data center or Bob's place. Mm-hmm. It's what actually happens inside.
Exactly, that's the name. And the idea that this ordinance is you have to specifically name the thing is clearly not true. You start in the B districts with retail. They don't list out all the thousands of ways that one can do retail. It's a generalized category. And this fits in a generalized category.
Okay, so is it your opinion that the data center use is a permitted use in the IB zone?
Yes, it's my personal opinion, but it's also the opinion of the town zoning officer, and I think he's right.
Okay.
City, sorry.
You've referenced the 2024 opinion of the zoning officer several times. And you've indicated from a professional planning perspective that that's sort of the gold standard right now because the zoning officer is the one who made that determination?
Oh, it's the legal standard. I don't know the gentleman. I don't know his background, if he's a planner or not. He went about coming to his opinion differently than I have, but I think he came to the right conclusion.
And nobody's here tonight trying to ask the planning board to make any type of a determination on that?
They ought not to be.
So, just a couple more questions, Mr. Ringkamp. Just having reviewed the planning history, I just want to go back through some things and just make sure I'm getting all of this on the record. Having reviewed the city planning history as a whole, rather than just considering the 2008 master plan, is it your opinion that Ordinance 2022-44 is substantially consistent with the City of Vineland master plan as amended?
Yes, that would be my opinion.
Okay. And did you find any substantive professional planning deficiency in the planning board's consideration of the 2022 zoning referral?
No, as I said, I wish I could tweak the language in a couple of places, but it doesn't matter. The substantive issues are all there.
Okay. And from a professional planning point of view, do you agree with Mr. Steck that the ordinance has to say data center in it?
No.
And are all of the opinions you expressed here tonight within a reasonable degree of professional planning certain?
Yes.
Okay. Mr. Rainkamp, thank you very much. I appreciate your time this evening.
Thank you.
That's all I have, Mr. Malinsky.
Thank you. Mr. White?
Again, Ray Went with the Went Law Firm. Mr. Rainkamp, we know each other.
We do. Do you mind if I stay seated?
Not at all. You mind if I stay standing? You didn't issue a written report, did you?
I did not.
Mr. Steck did.
He did?
I didn't have the benefit of looking at what you were going to say tonight in the way of the report, so I'm going to do my best. I also received an email from Mr. Freilinger this afternoon attaching new exhibits that I had seen for the first time in terms of this application, so I'm going to reserve the ability to look at that same way Mr. Freilinger did, but he said it was late submissions as well.
And I'll assume that's not a question to me.
It's not, just for the record. Is it your position that the Vineland ordinance is category-based versus specific-based?
I don't think that's a distinction that makes a great deal of sense. I understand Mr. Steck used that language. I don't find that in a text or a important document, a book in our field. I think it's a handy characterization that he used. I think, like most ordinances, it's both. It uses office and retail as broad categories, particularly in the industrial area when it wants to do prohibited uses. It's very specific as to what's prohibited. So I think it's a combination of both.
So if a statement is made that if use is not specifically listed in the zoning district, then it's not permitted, you don't agree with that statement?
Of course I agree with that. It's in every ordinance ever written. But the art is, when it says retail, does that include the donut shop and the jewelry store?
Or it doesn't include the strip club.
There are uses that have names that are within a category.
But the point of it is, some uses are one thing and other uses are another thing.
That's tautologically true.
And we're not talking about an office building with a bunch of lawyers. We're talking about a large facility that looks something like
it's young, I don't know, naval
I'm sorry,
Air Force
if
Base or
you
something.
take out the lawyers and you put in data scientists, or you put in biomedical researchers, then the buildings that we're now doing in the biomedical field are almost half computers and half researchers. You know, all the different fields have different professionals in the building. It doesn't change it from being an office.
But at some point, the use of the office and the intensity of the impact of that use in the office, doesn't that come into the equation of whether or not you can say it belongs or fits a particular use like manufacturing?
I'm not going to argue that scale can't matter, because I would be of the similar agreement that million plus 5 million square foot things in the middle of nowhere with no employees are different. But that's not what this is.
You equate the data center in terms of just physically how it looks to your average office building?
No, I didn't pick the architecture, but yes, it's
you've seen this thing, right?
I have. As I said, I'm not a fan of the architecture. I'm not going to defend it.
I'm neither of these folks.
Right.
But, okay, if you're going to stand by that, that's what you're going to stand by.
Yes, it's going to be the corporate headquarters of Data One with more than 50 employees, which fits under corporate headquarters or corporate office in the zoning code. So yes, this is not an empty building with just computers. This is actually a business.
You mentioned the redevelopment plan. It's safe to say the word data center doesn't appear in the redevelopment plan, correct?
I don't recall that it did.
So our argument in terms of the zoning code would apply to the redevelopment plan that it's not in there, so we say it's not a permitted use. I understand that's not your position, but
I understand that that's Mr. Seck's position.
okay. You mentioned, and I'm learning this for the first time, you mentioned your work with data centers over the last decade.
Mm-hmm.
You do a lot of data center work?
Again, the data center label is a brand new label. I've done pharmaceuticals that are half data center. I've done law firms that have 2 outbuildings that are data centers. What else have I done? I'm working on a larger data center now in Edgewater Park.
What type of data center is that?
I'm sorry?
What type of data center is that? Like,
That's still in the development process. They're looking for customers and trying to figure out what it's going to be, so that's still amorphous.
Something like this, or?
Similar.
Have you ever objected to a data center?
I do some objector work, and I'm just trying to think if you would characterize any of the things I objected to as data centers. Probably not.
Understood.
There are logistics companies doing warehouses in which a good quarter of the warehouse is computational power running their logistics models. Again, I don't consider that a data center, but 25% of the use of a large warehouse building was.
Well, hang on a second. You wouldn't consider that a data center? I thought you said data centers are very broadly, it's defined
Data center is this ill-defined use that people throw at things they don't like.
Ill-defined is a very good term.
I'm sorry?
Ill-defined is a very good term.
Okay.
Because we seem to just be defining this as it seems fit either warehousing or now it's an office building. Isn't it its own thing?
No. It's a tool. The computers are a tool, whether they're in a law firm, a medical center, a logistics center, a support for Microsoft selling services with a bit more than 50-person corporate headquarters at the front of it. It's a tool, and it's a larger share of buildings than it used to be. Go to any new insurance office building. They're 90% data and 10% people. The world is changing in terms of what's in an office building.
Yeah, but they're not asking for massive water hookups and all sorts of other utility-related issues and waivers and the like. Isn't it totally different?
They are. They're just not massive enough that people got excited about it.
Exactly.
Okay. I'll agree.
That doesn't make it different enough.
It doesn't change the use.
Shouldn't it be its own use?
I don't believe so, no.
We will have to agree to disagree. That's all I have. Thanks.
Thank you, sir.
Ms. Bellevue or Mr. Parks, any questions for this witness?
Thank you, Colin Parks, representing Sustain SJ.
Good evening, sir.
Good evening, how you doing? Good. So you were talking about the data center and we were talking about tools, right? You called a hammer a tool?
Yes.
You'd agree with me that a hammer factory is still a hammer factory, right?
Logically, yes.
So something making that tool is different from the tool itself, correct?
Sure, if we were making circuit boards, that would be a different use than using them.
You were talking about this data center being used to create software, right? So software is the tool. The computing power is what's creating that tool. You'd agree with me, right?
No.
Yes.
They're both the tool, they're both the equipment.
But you were telling us earlier that what's being created are these ultimate software end uses, right?
What's being created are the services that people are receiving, whether it's information, whether it's programs. The information that they're receiving is the product.
So the data center is providing what ultimately becomes the information, but it's your contention that the data center itself is the information? The data center is the hammer?
Yes, and the output is the data that people are receiving.
So the hammer factory is a hammer.
It's not making, they're not making the circuit boards there. And perhaps we've stretched my analogy beyond its usefulness. But my point is simply that the implements that we use in business aren't the use. The use is what the business puts them to, the product that they produce, the service that they provide.
So I guess I want to talk about the use of office space relative to other space at this site.
Mm-hmm.
You'd agree with me that a hammer factory with one office is still a hammer factory, right?
Sure.
You'd agree with me that a hammer factory that is, I don't know, let's say 75% hammer factory, that's not really an office building, right?
Generally, yes.
What percentage of this site is being dedicated to power generation and to computing resources?
Those are two different activities. One's an accessory use and the other is the primary use of the site.
Well, hold on. I thought you were telling us that the primary use of the site was office building.
You said power generation as a support for what's going on. It is not actually producing the service itself.
But just so I'm understanding, are you telling us that the use of the site is as an office building, or are you telling us that the use of the site is providing hammers?
If I'm working with a plastics extruder that has multiple tanks of things that it uses to extrude plastic, the extruding is happening in a building that we might agree is industrial or is a factory. The tanks themselves are just tanks that support that business that's occurring in the building.
So let's talk about that extruding, right? If 80% of the whole site is extruding, and there's a single office, you'd agree with me that that's primarily extruding and not office use, right?
Yes.
Okay, what percentage of Data 1 site is used for power generation?
Again, you're going to power generation, which is different than computing.
Well, let's just talk about power generation versus offices.
We have to get a civil engineer out here to do percentages of land area or square footage.
Is there a civil engineer coming, Mr. Freelander? There is no civil engineer coming. Do you think you could do your best?
No, my remit here was not the site plan. It was dealing with these use issues. So if you're asking me questions about the physical site plan, I couldn't begin to tell you the percentages or the numbers or the square footages. It wasn't in my scope of work.
If I posed you a hypothetical, could we maybe work with that?
Sure.
Let's say 80% of the site is used for computing, 10% is used for power, 10% is used for offices. Would you call that site an office building?
It depends on if we're talking about the output. Take an insurance building.
It's a very simple question.
No, look, if you get to ask questions, I get to give you answers. The question that you posed to me is an example, for example, that I would compare to an insurance business, and I've done a couple of those buildings. 10% of the building is actual people, 90% is computers. Is it still an insurance company? Yeah.
But would that be an office building? It's your contention that that's an office building?
No.
As long as there are 10% offices, it's an office building? Is that what I'm hearing?
Yes, they're routinely located in office districts.
Okay, thank you.
Mr. Freilinger, do you have any re-examination?
I do, just a couple, yes. Mr. Rainkamp, when you talk about office or corporate office or research and development, where are you picking those words from? Are you just picking it from everyday language, like from Webster's dictionary? Where are they coming from?
Typically not Webster's dictionary, which tends to use words in a different way. There are thesauruses and dictionaries within the planning profession. Moskowitz is a famous one. There's a thesaurus that was put out, I think, by ULI. So there are word books that I referred to in preparing for this, but it's also decades of practice in the field. I'm doing applications for offices and industrial uses routinely.
Isn't it also words that are used in the Vineland Code?
Well, yes. I mean, ultimately, that's what we're comparing these concepts to.
Okay. So in the Vineland Code, the concept of office and the concept of corporate office and the concept of research and development, I think you mentioned, they all have specific definitions, do they not?
Business office and corporate office do. I'm not sure research actually has a definition.
Okay, and for that one, you'd have to look at Moskowitz,
yes,
so to speak. Okay, so business office, corporate office, whatever, fabrication, manufacturer, they all have definitions in the code. And isn't that the first thing you look at?
It was.
Okay, and so does it matter how big the building is if it meets the definition of an office?
Does not.
Okay. Does it matter how big an accessory use is on the site if it meets the definition of an office?
It would meet the definition of an accessory use in that district.
For the office?
Yes.
That's correct.
Yes.
Does it matter how big the accessory use is?
No.
To the office?
No.
It does not?
No.
So it wouldn't matter if the accessory use took up 25% or 50% of the site?
Yeah, numbers get dicey in planning. You can go to an extreme and you all say, oh, that doesn't make any sense. But as a general rule, no, it doesn't.
Right. So what you're actually saying is that the data center use being the use that this data center is actually being put to meets the definitions that you've found in the code for office, corporate office. You also likened it to a research and development. And, you know, my favorite is obviously fabrication. You and I talk about that a little bit because you can fabricate with these computers. So does it have to fit into one use or could it fit into a myriad of them?
Well, I think that's the approach that Mr. Finley took, that he looked and saw a bunch of analogous uses and led to a comfort level that it was permitted. I've gone a step farther. I think there's actually a category it fits in, and that's the business office with services for fee. So I would have been specific and said it absolutely fits here, and here are these other analogs that I think make me comfortable. So I would have approached it slightly differently, but yes, to your question.
Okay. So you agree with Mr. Finley just for different reasons?
Yes.
And all
well,
of this...
His reasons plus, let's put it that way.
There you go. His reasons plus. But all of this conversation that we're having tonight, does it really matter because Mr. Finley had issued that opinion?
Well, it doesn't matter to this board. It may matter someday in the future in front of a gentleman wearing a robe.
Right. But in front of this board this evening, does it make a difference?
No.
Okay.
I don't have anything further. Thank you, Mr. Malinsky.
Any follow-up questions, Mr. Warren?
You referenced the zoning officer a number of times in the zoning officer's letter. I just wanted to follow up with a quick question here. And it says, in the letter, it says, and this is from February 21, 2024, it is my opinion that the proposed data center use, as described, would be a permitted use within the IB zone. Isn't it true that at the time of this letter, the proposed data center didn't include any power generation?
I wouldn't know that.
Would that make a difference in terms of what?
No, that would be whether or not it had a supporting accessory use.
That's all I have. Thank you.
Thank you, sir.
Ms. Bellevue and Mr. Parks?
Hey there, thanks again. So I have two questions. First, did the zoning officer sign that letter that you're talking about?
Well, I can't attest to his signature. It has a signature on it.
Okay, thank you. And the second is, I got that data. If there's 2.6 million square feet for data center and 169,000, and we're being generous here, for office, parking, and site development, it's still your contention that you could call that an office building.
It still meets the definitions in the zoning code for a corporate office center or for a business office, yes.
Thank you.
Mr. Fralinger.
Nothing further.
Okay. Mr. Fralinger, do you have any more rebuttal witnesses this evening?
I do not.
All right, at this time, we're going to turn to our professionals for questions for the applicant. Or we'll go to the professionals first. If there's anything that's not been discussed in your reports that needs further discussion, anything from our professionals. Kathy, nothing.
I believe my reports were addressed primarily at the last hearing.
They were addressed at the last one. All right, board members, any questions, comments before we go more to the public? Anything at this point? All right, at this point now, oh, sorry, Mike, go ahead. Okay, so at this point, we're opening up to the public, the microphone obviously here. If you'd like to line up in there. And just again, as I mentioned earlier, we are going to allow you to speak your mind. Try to get to your comments, limit that to that time frame if you can, so that we can get to as many people as would like to be heard. So what we'll ask you to do is state your name and your address, and then we'll move forward.
After you're sworn in. Please. Do you swear to tell the truth, the whole truth, and nothing but the truth this evening?
I do.
Please state your full name slowly and your address for the record.
I am Helen Petrides, Petrites. I live at 1616 Pennsylvania Avenue in Berryman's Branch, Vineland, New Jersey.
And thank you for spelling your last name.
You're welcome. My appreciation to all of you who serve. I stand before you with a petition in hand, which I delivered to the clerk this morning with 3,100 signatures, asking the board not to approve the phase 2 of this data center. I'm leaving all the other discussions and the professionals to argue the points. I'm just here to be on record that I went and got 3,100 people to sign this because they can't be here. Thank you for your time.
Can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth this evening?
I do.
Again, please state your full name and address for the record.
My full name is Stephen Arthur Lewis. My address is 1322 Brandywine Drive, Vineland, 08361.
That's S-T-E-P-H-E-N or S-T-E?
S-T-E-P-H-E-N. Thank you. Lewis is L-E-W-I-S.
Yes, sir.
All right. Tonight, I have questions about the building of the data center. I made copies that I want to give to you up front, and these copies show the only approved plan that's been approved by the planning board. There was a second plan, right? You had 2 meetings, both times, data center canceled. Now we have this third one, right? It's altogether different than the first. So, if you don't mind, I'll bring these up and you can pass them out, if that's okay?
Ryan, you can give them here to Ryan, and he'll make sure we get them. And then, Mr. Lewis, if you want to tell us what it is that we're looking at, what it is you'd like to say about this?
Sure. What I'm sending up to you right now is a photo that I took when I went to look at the Site 1 plan, which is this one right here. It's the first paper of the copies. The second picture.
Hold on a second, Mr. Lewis.
Okay, I think we all have it now.
Okay, Mr. Lewis, I'm gonna mark this as exhibit Lewis 1. It consists of 3 black and white, 8.5 by 11 sheets of paper with various versions of the site plan. Go ahead.
Okay, now, the site plan that you have here now is a third one, right? And the reason I'm doing this is because I want to show you how it progressed. And my first question is, when the first site plan was approved, can Data 1 change any buildings or do any different improvements on the property? Otherwise, you have right now, you're showing that you have two stop action slips for Data 1, right? And if you look at the first site plan, there's no LNG gas on there. And that is another question.
Is that the first picture?
Yeah, the first picture is site plan 1.
Okay.
Okay. Now that doesn't show LNG gas, but they also show on that picture there's two main buildings. And the last building is diagonal from the back of the property. Okay? And well, I took notice as I'm driving by that as I look at the side of the building, right, there's a curve in one section of the building, right? And to me, right, if you look at the second site plan, there's a picture of a building that has a curve on it, but it's not connected to the main building. And as I look at the building as it stands now, that building is there, and it is never placed in what it would show on site plan 1. Which makes me think that they decided to do something on their own, and they just did it. Okay? Pardon?
Do you have anything else?
Oh, yeah.
Okay.
Yeah, I'm just getting started. Thank you. Okay. So basically, what would the planning board do if Data 1 started changing how the buildings were built, or they were replaced, right? Would that be against the law in order for them to do that?
The planning board has no enforcement authority.
Okay.
The enforcement entity is code enforcement or the construction office.
Okay.
So to get back to your initial question,
Yeah, that's the question.
a developer is supposed to build their development in accordance with the approved plans.
Okay.
And if for some reason something deviates from the approved plans, that's why you have the construction office and code enforcement that is supposed to prevent that from happening.
Right.
And issue, whether it be notices of violation or stop work orders in that sense.
Okay.
But this board has no power, authority, or enforcement authority whatsoever.
But the city of Vineland does have power authority
They
somewhere.
do, and they have the authority based on any resolution that's passed by this board. Any developer has to construct in accordance with those approved plans and that resolution. And if they don't, then the city has a document to enforce, plans to enforce, and a document to enforce to stop the developer from doing that.
Okay.
But again, that's not this board.
Okay. And then, of course, the planning board has no say over what they charge per day for Data 1 when they started building the...
No.
No, but that has happened. you know, and they have received that. So, now, if you go and you look at your site plan that they want your approval right now, okay?
And that's sheet 3.
Correct. Okay. So on that, they're showing phase 2, which is a small section behind the main building compared to what it showed on page 1. So they made that shorter, right? Then, and of course, the building that's up there now, it appears to me that it is a lot longer. It goes back a lot farther. And now they're showing the bloom powder source on page 3. And that takes it, that power supply goes all the way to the back of the property line. And what I'd like to know is that going to be inside a building or is it going to be outside all the time?
Mr. Fillinger?
They are outdoor units. They are all encased in their own shell, so to speak.
Yeah. So, being as they're outdoors, what happens if, for instance, lightning strikes that section of property with all that power source there, with the natural gas there that's feeding it? You know, to me, it's not good for them to be outside, but that's where they put them. But if that happens, now we have a disaster, as far as I'm concerned.
Well, they are all grounded, so they are lightning resistant, just like the LNG tank, the testimony that you heard at the last meeting.
Okay. Has the Data One Center received any code violations before these first two that we're talking about now? They have none, right?
That's not anything that we're.
Okay. The other thing is at the last meeting, it was mentioned about a number of fans on top of the building, and I believe it was 40, if I'm correct, or was it more?
I don't know what he's referring to.
Well, on the one building that they're showing in the front,
Correct.
they were saying that there would be fans on top of that building.
The dry cooler units,
Yes.
they're there now, yes.
Okay. And how many are up there?
I don't know off the top of my head, but I might be able to get you that answer tonight.
Okay, well, I believe at last meeting you said there was 40. So my question to that is, now we have a problem with noise today, right? So the number of fans up there, how much noise will that make that the people will have to listen to maybe 24/7? I know you don't know the number, but...
No, I don't know the number, but I can tell you what's happening with those dry coolers, because that's part of the noise mitigation report that was talked about at the last hearing. There will be a noise wall put up around the top of that first shell of the building, and there will also be acoustical draperies on the interior of that wall as well as on the back of that wall. That is required per our acoustical report that has to be done. So that will be done.
Okay. It also was, excuse me, it was also brought up tonight about that property at one time was mining, right? And that in order to make it viable to build on that, a lot of the holes had to be covered up, leveled off. So before they started the building, did they do any ground tests to show that actually that property will actually hold the weight of that property over any time of number of years or whatever?
Yes, there's been a series of geotechnical reports that have been done for the property, just for the purposes that you're talking about.
And did they actually do any kind of technical ground testing?
Absolutely.
They have, okay. And they are okay.
Yes.
Okay.
Yeah, we would have to do that before we can place any building anywhere.
Okay. So, my last, it's going to be a comment, right? I believe that when you do something like this, you're supposed to be honest with people, show that you're truthful, and be respectful. Well, from what I see right now, I don't think they're very respectful to what's going on. There's a lot of people coming here complaining, telling their stories, what they have, and we have people that have medical problems, right? And so I don't have a lot of faith in that one myself, but maybe they'll prove me wrong in the future.
Thank you, Mr. Lewis. Thank you.
My name is...
Can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth this evening?
I do.
Please state your full name and address for the record.
My full name is Lynn Denise Hazelwood. I go by Denise. What else did you want?
Your address, please.
524 Oxford Street in Vineland, 08360. I've been a Vineland resident for almost 20 years. I've put my kids through the Vineland school system from preschool through high school. So I'm a long-term resident, and anyway. I'd like to talk about the use of the data center, first of all, and let me start with the accessory use of the power generation. Okay, last time I heard that the output of CO2 for this non-combustion chemical process, the CO2 output was going to be something like 2.19 billion with a B pounds of carbon dioxide. And at that last meeting, it was said that it exceeded the New Jersey power grid output, but I understand that there was some semantics in there, and actually it's something like 10% of the entire New Jersey grid output for the energy generation, carbon dioxide generation from this proposed data center expansion. That's some damn accessory, you know? It's like, if you're getting dressed and you put this 50-ton crown on your head, I don't see that as an accessory use. I see that as a big problem. Let's see. Regarding the primary use of the data center, there was a question I asked when the gentleman from France was here. I asked him about how this data that would be generated would be used. And I gave an example of like medical research as a positive use, but I also said, well, you know, what about deep fakes and propaganda type uses and things like that? And his response was that he could not control how his clients would use the data center. And that's very concerning to me. I mean, like, medical research is one thing, but when you're creating propaganda to convince the public that something that's not true is true, that's something else entirely. And that concerns me that we do not know what the use of the data center exactly is going to be. I heard people last time talking about in the meeting a 3 weeks ago, talking about the noise mitigation plans. One thing I did not hear, and I was kind of listening for, was the term ELFs, and maybe the technical jargon that was being spouted addressed that, but ELFs are something that you really, the human ear can't hear, but it does have a deep impact on one's health and everything else. And so I would kind of like to know about the ELF output from the noise generation of this proposed expansion. And even the current data center that's there, that's the stuff that's already existing. What is the ELF output? And I really haven't heard anything about that. There was a lot of talk about how safe this proposed expansion was going to be, like the LNG storage tanks, and how they were going to be impervious to lightning strikes, and what did they say? It's supposed to be able to withstand a small projectile at 90 miles per hour. Well, I'm not sure exactly what small projectile is, but I'm thinking about, Ukraine and Russia sending drone attacks on each other and blowing up each other's oil refineries and everything. And I don't know how this proposed data center would stand up to a terrorist attack like that. What if there's a drone armed with explosives that some terrorist sends to the data center? Or a swarm of drones, how would it stand up to any of that? And I didn't hear anything about that. What about an airplane crashing into it? We had the 9/11 airplanes crashing into buildings. I haven't heard anything about that. And I do remember at a previous meeting at the City Hall, somebody saying that this data center would make Vineland a target for attack in the case of terrorism or anything else. So those things are a concern to me. But I guess the biggest thing to me are the two that I started out with, the CO2 emissions in this day of climate change, when we need to be mitigating our carbon output. And this one data center in one city in New Jersey is going to output something like 10% of the entire New Jersey grid. That's big. And I don't think, I'm asking you not to approve this plan. And the other thing was the use, it's an office building. Well, no, it's not really an office building. It's this giant data center that's going to be creating AI that we don't know how it's going to be used. It could be used for the deep fake propaganda stuff. It could be used for the medical research, I suppose, but the uses that they don't know about, because I asked the guy, how is it going to be used, and he could not answer me. That also concerns me very, very much. And that's all.
We appreciate your comments. Just a couple of things. The first off, obviously, we're all concerned about any kind of attacks on any of our infrastructure, any of our buildings. Your comment, and I'll have to ask Mr. Fralinger to comment on this, your comment about the CO2, again, I don't know all the details. I think that comment came from someone in the audience, not from your professional, and I believe that was not the case. If you'd like to comment?
No, that's correct. That was a comment that came from an audience member.
It came from one of the attorneys for State.
But the expert from the energy company, I think, spoke to that.
That's correct, and gave the number as to what the CO2 output is. I don't know anything about.
Could you tell me what that number is?
But I can say that CO2 is not a regulated air pollutant in New Jersey for minor source air permitting, and even for major source air permitting, unless you're dealing with some type of a public utility, and then it's not necessarily regulated. It has to be reported, and there are other programs that people can get into
to buy credits, green credits, whatever they are. But it is not a regulated air pollutant in New Jersey.
10% of, carbon, it's carbon and CO2. And we're in a situation where we've got record high temperatures, record freezing temperatures, and we need to be mitigating our carbon output, not drastically increasing it. So if you could tell me what that number was that the expert heard, because what I heard was the 2.19 billion, that it was, at the time I heard that it exceeded New Jersey's entire grid output, but I understand it's actually only 10% of the New Jersey grid output, but that's still a lot. So if you could tell me what the actual number is, if that 2.19 billion is not it, what is the actual number?
I can get the number. I don't have it right now, but I can get the number.
Okay.
And then we'll have our next speaker step up. I just have one other comment, Mr. Frailinger, that you brought up. I forgot to ask you earlier. Earlier there was mention of a letter from the fire marshal from the city. I believe the attorney said that the fire marshal had concerns. When I read the letter, it was a list of things that they required. Tell me, what was that list, and has that been provided?
No, it has not been provided. That's the NFPA 59A checklist of things that will need to be submitted to the fire marshal upon an approval.
After the approval,
then it gets submitted to the fire marshal for review of the design plans for the tank. It's sort of like making a building permit application. You don't make a building permit application, 2 months or 3 months in advance of an approval.
In your conversations with the fire marshal, did they have any concerns with the plans, the LNG plan?
Absolutely not, no.
Dave, just so you know, over here. The approval from the fire marshal or the representative for the LNG tank with respect to 59A is a condition of our approval in my report.
Correct.
So all those documents have to be.
They have to be provided. They won't go to me because, to be honest, I'm not a professional in that. They'll go to the fire marshal or their representative to do their review, and they have the expertise in reviewing the tank.
We go to our next person from the public, please.
Yeah, I just want to leave you with, please, I'm begging you, do not approve of this, or vote no against this extension. Thank you.
We have our next.
Can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth this evening?
I do.
Please state your full name and address for the record.
My name is Daniel Conley, 4815 Covered Bridge Road, Vineland, long-term resident. I live about 1 mile as the crow flies from the data center. Yes, the noise keeps me up at 2 in the morning and does wake me up. And the previous speaker talked about extreme low frequency sound. First question, do you have a sound engineer who works with the full spectrum of sound and mitigating it? Because it will change as you build. It's loud enough now, but there will have to be mitigation and tweaks as the project continues. Do you have a sound engineer?
Yes, we do.
And is he making changes as you build to mitigate the sound?
Yes, he is. And that was part of his testimony. I don't know if you were here at the last meeting, but yes.
The second thing is, we talk about possible flooding, talk about 100-year floods. There have been historical floods in that area within the past 20 years, including one which went down Hansbridge Road between Hansbridge and Lincoln and temporarily closed 55. Has that been accounted for, historical floods and what we know will happen, not what is theoretical?
Well, not with the data center, it hasn't, but with the golf course, it was accounted for. There are still more drainage impacts or drainage improvements that will be going in Hansbridge Road as part of the golf course development.
Thank you. Data centers are going up across the country by the thousands, and planning boards and zoning boards have difficult jobs all across the country. Their job, because they are in a competition to build first and fast, mistakes will be made, and it is up to the zoning boards and planning boards to really go over it with a fine-tooth comb to make sure it's done right and done safely. And I know you have a difficult job, but you also have a lot of power. So if you see something that needs to be changed, do it. They will take care of it. And make sure that it is done first, because they seem to have a habit of doing things first and then asking later. And thank you so much for your time.
Thank you, Mr. Conley, for your comment.
Thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth this evening?
I do.
Please state your full name and address for the record.
Hello, my name is Eligio Rodriguez. I live at 332 West Cherry Street, Vineland, New Jersey. I have been a Vineland resident since 1969. And this is the worst shape I have seen the city since the data center issue came to the city. One question I have, who's going to pay for all the fire trucks that we're going to need for that data center? Because we're getting tired of paying taxes every year.
I'm sorry, could you say that again? Who's going to pay for?
Yeah, who's going to pay for all the fire equipment that is going to need it for in case of an emergency on that data center?
Again, our job here is to look at the municipal land use law and the zoning ordinances and the fact that there's extra fire equipment that's needed. That's something for the city to address.
Well, you should have somebody, representative from the fire department today here to answer those questions. And you should have Kinley also down here, since his name was mentioned. And also, sir, I got a question for you. Do you allow a data center over your town right now? If we agree, everybody here put money together and put a data center over your place, answer yes or no.
I live in Vineland.
Well, you should not live in Vineland because you neglected our city. You sold our city. Also, I'm going to address all of you have been appointed by the city government to vote no on this resolution. Please do it in behalf of you. Kids, grandchildren, great-grandchildren, and future kids of Vineland.
Thank you, Mr. Representative. Thank you.
My name is.
Hold on one second.
Excuse me?
Hold on one second. Let me swear you in. All right. Raise your right hand again. Do you swear to tell the truth, the whole truth, and nothing but the truth this evening?
Yes, sir.
All right. Please state your full name and address for the record.
My name's Kathleen Smith. It's 1616 Pennsylvania Avenue, Lot 200, Vineland, New Jersey, 08360.
Thank you.
I live 1.5 miles away from it, and I've only moved into Vineland 4 years ago. I moved there because it was a beautiful area. It was close to everything that I needed as a retiree. Then I get thrown into my face a little shock of horrors. And that's what I call this. Because this will not end. They asked for 1 megawatt. Then they asked for 125 megawatt. Now they want 300. The problem with 300 is our grid cannot handle it. So you allow them to apply a system that has never been used in this magnitude. But it's okay because they say it's okay. I've heard, no, I don't know. DEP, no, we didn't answer that. The DEP again, no, we don't need to have the value, then we'll tell them later. And then we go, oh, I believe so. I believe. You need facts. You don't, I believe anything. So what is created is a monster. The monster who will want constantly to be fed, because I already know they said phase 2. That's all we're looking at. They already have phase 3 figured out.
They're already working on phase 3. And we have a neighbor who is building two 500,000 square warehouses that are supposedly, we don't know what they're going to be used for. They're next door to the data center. Are we fifth graders? No. So I am angry with this. And I say vote no, because there's too many unknowns.
Just one point of clarification. You just said someone's building two warehouses that we don't know what they're being used for?
Next door, Northeast Cast, you already approved, the
Oh.
planning board already approved.
No, we know what that's being used for. They're
What
that's
will they be used for?
they're for building concrete panels. That's what their company does.
Base Amazon says that too. And Amazon, half of it is computer, and then they use the rest as so quote, we're shipping you stuff. So I do not believe that. I feel that this was, I have no words.
Understood. Okay. Thank you for your comments.
Thank you.
Can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth this evening?
I do.
Please state your full name and address for the record.
Eric Rodriguez, 322 West Church Street, Vineland, New Jersey. So, here we are again, another meeting. I know everything's a process, especially when you're a big city like Vineland. But we are in the spotlight. Not just the local news, not just the regional news, nationally. Vineland at least is showing up 3 or 4 news channels nightly, daily. You have people from out of state, out of the country, looking at us because a data center of this scale is being built for the first time with different technologies, they're like, it's gonna work, it's gonna be fine, but the scale is unprecedented. The city, we're being the litmus test for surrounding areas, surrounding counties, the state. Every time some other data center is being built in Pennsylvania, they're like, well, the residents of Vineland right now are in a fight, they're in a discussion. Everybody's trying to figure out what is going on. Now, data center can bring something good, can bring something bad. But ultimately, we're in Vineland. You're having a very large construction project with, essentially, we're the guinea pig. We're the test bed to see, how does the construction process go? Is it easy for them to build continuous data centers doing the same process with different technologies with the fuel cells? It's like the scale. There's so many unknowns. You have so many people asking plenty of questions. You have concerns with health, the environment. You have a corporation that says they've been forthcoming, but it's been hit or miss. And we just implore everybody in the city to please pay attention. All our elected officials, all the boards, please do your due diligence. This isn't something that needs to be rushed, because ultimately, residents of Vineland, win or lose, we're not going anywhere. We're stuck with the success or the failure of this data center. And it frightens a lot of people because there can be good things out of this, there can be bad things, but there's more questions about possible negative impacts on not just our community, New Jersey, Delaware, the surrounding cities. I mean, it's literally covered the spectrums from people's property values to their health to, the environment. This is a big deal. A lot of the residents feel blindsided when this project was brought to light to the mass majority because we all thought, there's going to be another golf course. Next thing we know, they're like, okay, they're building a computer thing. Next thing we know, it's a data center. It's going to be this size. They're going to use this technology. It just keep expanding, keep changing. We had a town hall meeting that everybody's like, all right, we'll be put at ease. But ultimately, it caused more concerns, and here we are again. I would say you don't need to rush this. Don't vote yes on this at all. Vote no, because I've heard plenty of people up there, down here. There's a lot of questions and a lot of answers we're still waiting on. So, thank you.
Thank you, Mr. Ledger.
Can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth this evening?
I do.
Please state your full name and address for the record.
Robert Tomaso, 385 West Oak Road, Vineland, for many, many years. And some of the comments prior here, I'm really in agreement with. Too much is unanswered. It's a risky project. A couple of things I'd like to ask questions about. Number one, I hope that you will really look into this business with trucking in liquid natural gas. Route 55, we know, is what has to be fed into this system isn't going to stop on a weekend when all of the shore traffic comes down here, and so on and so forth. We could be looking at some really bad accidents. Liquid natural gas explosion, as far as I know, is pretty dangerous stuff. They have them on site, and we're going to have them right here on the highway, on our city streets, perhaps. I know Oak Road is a good example. We're the go-between the produce auction and the freezer companies over on the west side of town. Oak Road has turned into a major highway. The truck traffic is unbelievable. I mean, a lot of safety considerations that I probably can't even envision. I've replaced my mailboxes at the street with the kind that open from the back. I don't want to walk around the front of that mailbox anymore because there's no, shoulder. And I'm not going to lean around and look in, a truck will go by or a car or a mirror knock me off my feet. You've got a lot of danger with a lot of these things. Please consider those things. Please do that. Now, I haven't attended any other meetings. This is my first one. I'm reading some of the documentation. Now, from what I understood tonight, again, correct me if I'm wrong, we talked about groundwater, okay? We didn't talk about the use of water in any of this. Maybe that was covered earlier. If it was, I'd like to ask a few questions just for my own edification. I read 8 million gallons a year. Now, tonight I heard because they're going to go with double or whatever, are we talking 16 million gallons? Somebody said 28 million gallons a year of water being used. We talked about wastewater. What happens to that water? I'd like somebody to please fill me in. Where does that water going to go?
The 8 million gallons that you heard tonight, that's with the cooling system.
Right.
That's the average utilization on a yearly basis will be the 8 million gallons. The 27 million gallons you heard tonight was the modeling of the worst case year. So the 27 million gallons would be stored on site. And then those 27 million gallons would be what the data center utilizes. And they'll utilize an average of about 8 million gallons of it on a yearly basis. It's to avoid against the drought condition. That's why the 27 million gallons is there. Now the 8 million gallons it's utilized in spray misters for fans. So it's evaporative. It'll be sprayed into the air and it'll evaporate.
But this huge reservoir on site
Correct.
could become groundwater in some capacity.
Absolutely not.
Absolutely not.
It is lined and it's also topped.
Well, we've had some pretty bad hurricanes and things like that. And this thing is all hurricane proof. I don't know if I...
It's the same size as the reservoir that feeds Trout National.
Well, then I don't know if I trust that one either. And you know, where it's going, and on the other side of that, we're drawing that water from the aquifer. Is that correct? Right?
It's city water.
the city's gonna supply it. So the
Correct.
city's drawing it from there. But that's, how does that number stand up against what citizens use? I mean.
It is a very low number compared to other industrial uses in the city. This particular project could drill a well just by getting a standard well permit and be able to draw up to 36,000 gallons per year without getting a water allocation permit. I'm sorry, 36 million gallons per year without a water allocation permit.
Okay.
It would just be a water registration or a water use registration. That's all that would have to happen. And they could drill their own well into the aquifer and do that. By taking the city water, they're actually paying the city for the water. The city is getting paid for it. Yeah. As opposed to just taking it out of the aquifer, which they could do for free.
So the taxpayer is not gonna have to.
Mr. Tomaso, let me just address that, because it's actually something I know a little bit about. I've been in the food production business for my whole adult life. Our company that makes food products uses about 60 million gallons of water a year in a food production. And there are several food production companies in the city of Vineland that use in excess of that. But that just, again, 8 million sounds like a big number, and it is, but just to give you a reference if you ask.
Yeah, no, my concern, I ride through East Vineland, and everybody is irrigating because the rain hasn't been there, and so on and so forth, and everybody's drawing from these aquifers. So it was important to me anyway to know, quantify just what we're talking about here, I mean, it's interesting to me that a lot of times we'll get a notice, cut down, don't water your lawn, and so on and so forth. The city wells are having trouble, and so on and so forth. I would hope if that happens in this regard, are these folks gonna also not water their lawn? I mean, are they gonna stop drawing?
That's why they have a 28 million gallon reservoir in case there's a drought.
Okay.
Because they have to.
All right. Okay, well put. All right.
Thank you,
Very
Mr.
good.
Lassie. Appreciate your
Thank
time.
you.
Hi, good evening.
Hold on. Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth this evening?
I do.
Please state your full name and address for the record.
My name is Carrie Ann Phillip. I'm not a resident of Vineland. I wanted to become a resident of Vineland. I just moved down to South Jersey recently. I worked for...
What's your address?
Oh, I'm sorry. I live on 728 Aston Martin Drive in Lindenwold. And I moved up here a year ago. I used to work for the town of Princeton in their planning office, and I was with them for 31 years. So I'm very familiar with the planning process. I found it very difficult to get information on this project because I went online. Notices were difficult to find. I found no mapping. Fortunately, because of this, the South Jersey group, they were able to provide me with some detail. But then once again, I went to the meeting and it went into the wee hours. And when the attorney brought to fact that the zoning map that was online was inaccurate, that it had the residential zones on it, that everything was basically, should not even have gone further because it is the jurisdiction of the zoning board, if that is the case. If someone did not file with the county properly, it is never formally done, so it's not zoned properly. I just wanted to read you a few of my opinions because having that sign up there all night long helped me, not at all. I would be very nice for have reports up there or something that's referenced. I didn't hear any testimony from our professionals, only their professionals. It was basically gone over, oh yeah, everything's done. What's really concerning is the Benoni gentleman there. He's had his back to the audience the entire time, and everything is engineering, and I don't get it. Okay, so I just wanted to read a few things. Okay. I'm very sorry. I'm going to say. Okay. Okay. Special meeting of the planning board that was held on Wednesday, August 5th, lasted until midnight. And then I saw the generation of some revised plans going around to not take into respect that residential lot. I don't know if that's a fact. I was not able to locate that again. But I couldn't imagine anything being revised to make this fit. But now I'm getting the feeling that you're going to proceed with this.
Nothing was revised from the previous meeting, the same application.
Thank you. Yeah, it wasn't identified that way, but I thought I saw something. So, about a month ago, I heard about Pittsgrove next door doing, they were looking at databases, data centers, and they decided to prohibit data centers in all zones in their town. And I had done my research here before going to Pittsgrove, and when they turned around doing that, I cheered. I was just so very happy. And then I went home comfortable, and then I heard about the second expansion to this location. So I came down here and I did a lot of investigation. I ran into a resident that lives right across the street, and she described to me all the problems that she and her husband were having. The decibel levels were through the roof from 9 p.m. until 4 a.m. every single day. So doing a reading at 5 o'clock in the morning, that made sense to me because he didn't want to do it when it was really active. Considering the number of people that are opposed to this project, having a second special meeting in the month of August is really unfair because it does not give the citizens an opportunity to speak because they're vacationing or they weren't aware of this change. Phase 1 is currently being constructed, and if it's not really a permitted zone use within the zone or in the zone plan, then there should be a stoppage on that. And the fact that they did get a certificate of stopping any construction on site, that says a lot. And they did work without obtaining a permit. That's huge. Okay. When I went to the Vineland location, I noticed that there were solid walls and there were spikes on top of it so people couldn't cross, and there's signage saying, do not trespass. But the plan that you showed a week and a half ago had landscaping on the inside of the wall. And isn't that lovely? Who gets to see the landscaping on the inside of the facility? Only the workers. So if you're going to do landscaping, you put it on the outside so the public's not impacted by that. And why your planner didn't pick up on that, I don't know.
There is landscaping on the outside
There is
of the wall.
landscaping on the outside.
There was?
He did pick that up. Yes, I did.
Not the plan you presented, it was a solid wall and the landscaping was on the inside.
There is also landscaping on the inside, but there is landscaping on the outside as well.
It would have been helpful if those plans were shown, because I know that they were also asking for a waiver of site
They were
plan.
shown. The plans were shown,
Not
but
last week.
they were. But what I will tell you is, it's obviously a big site, so it's hard to see a small tree on the outside of the wall on that plan.
No, you would have to do adequate landscaping.
Well, yeah, I can tell you there is adequate landscaping in compliance with our ordinance along the front. That will be there along the frontage of the Lincoln Avenue.
And Ryan, wasn't that approved on the initial application, the first phase?
It was. It's one of the outstanding TCO items right now.
Well, before you move on to phase 2, don't you finish what's needed in phase 1?
They have time limits to get things done that are part of their approval.
Well, that should also go for phase 2. There should be a time limit before you proceed with your next phase.
That's not the way planning works. They have a certain time frame for one approval to get done. Another approval would be a separate timeline.
Okay. And my final question is about the sound attenuation methods. Finally, you brought something up that's really wonderful. When are they going to be installed, and what do they look like?
Well, some of them, they've already started, and there will be a sound attenuation wall on the northerly property line. There's berming that's in place. That berming on the northerly side has been planted. It does have trees on top of that berming. There will be vegetation planted on the berm that's at the back of the property as well. The sound attenuation wall will go up. That's being prioritized. We're hoping to have that up in by end of September, early October, hopefully. If not, sometime in October, we believe we can complete the sound attenuation wall. There's also parapet walls that are going to be going around phase 1 of the building up where the dry coolers are. They will be sound attenuation for the dry coolers. That's really what is required under the mitigation plan in order to bring the site into compliance. So the main thing is the sound wall on the northerly property line, and that's why that is being expedited in the process. But we would need an approval for that to move forward. That's part of this particular plan.
All right.
Thank you, Phil. Thank you. Just before you go, Kathy, you have a question, a comment?
You entered the exhibits regarding zoning in the corner. Did you give any testimony on that? I don't believe Craig Rainkamp covered that.
The exhibits for the notice?
That it was properly done, the rezoning.
Well, yes.
The notice to property owners.
Oh, well, not the notice
county.
itself. That's just
I
entered in.
think that's
just,
what she was referring to.
Oh.
Was it a proper ordinance?
Well, no, the documents were entered into the record. I mean, I can speak to those documents, they're in the record, but what those documents indicate is that municipal land use law was followed with regard to noticing for the change in zone. All the proper notices were made, they were sent out by the clerk's office. The proper parties were served. That's basically what those documents indicate.
Thank you.
Sorry. You swear to tell the truth, the whole truth, and nothing but the truth this evening?
I do.
Please state your full name and address for the record.
My name is Haley Curich, 2005 Indian Drive here in Vineland.
Can you spell your last name? Sorry.
Purich.
And what's your address?
2005 Indian Drive.
Okay.
All right. Hi everyone, my name is Haley. I am a housing attorney here in Vineland, but I'm bringing my understanding of property law, planning, zoning, and municipal land use law today in my capacity as a concerned Vineland resident. I want to begin with land use. So according to Vineland Municipal Code section 425-269, land shall not be used for any purpose other than those allowable in each zoning district as designated herein, i.e., any use not enumerated in the applicable zone as a permitted use, a conditional use, in which all specific standards are met, or as an allowable accessory use are associated with a permitted use shall be prohibited. So I want to go through some of these proposed uses because it seems like some have been proposed and then dropped. So I just want to be really, really clear about what the proposed permitted uses are. So first, there was discussion about the use being as a warehouse. Mr. Fillinger, is that still the case?
There was never a discussion about that from the applicant.
Okay. What about as a public utility?
The public utility would fit a permitted use for the power plant.
I disagree, so let's go through that. Under our municipal code, a public utility is defined as any utility, authority, commission, special district, or other corporate entity. I believe the applicant stresses this other corporate entity component, whether regulated or not by the Board of Regulatory Commissioners that provides gas, electricity, water, sewerage, telephone, or cable television service. Again, while Data One emphasizes this phrase, other corporate entity, in support of its argument that power generation should be considered a public utility, a more apt reading would instead emphasize that the utility must be a utility service. Thus, it must be provided to somebody else besides the corporate entity making use of it.
It is.
And who is that to?
The other customers that are at the data center. Data One is supplying it, and it is going to Nebius and Microsoft. So it is being supplied to them. And Data One is a corporate entity under New Jersey law, and it's also unregulated by the BPU. If in fact they were actually serving people off of their property, they would have to be regulated.
That's why the ordinance reads the way it reads.
So your understanding is that you constitute a utility service because you are generating energy to operate the data center? You're providing energy to recipients?
It's not. It's unregulated. Now, the definition calls it a public utility, but we had a planner up here talking about labels and definitions and things of that nature. They call it a public utility. It's not a quote-unquote utility. It's a servicing one entity on the same lot.
So, under the definition of public utility
Yes.
in our municipal code,
Yes.
to constitute a public utility, you need to provide gas, electricity, water, sewerage, telephone or cable television services.
Correct.
Which one of those are you providing?
Electricity.
You are providing electricity to your
To the data
purchases.
center. Correct. That's like that's what the Bloom fuel cells do. They provide 300 megawatts of electricity, and it gets supplied to the data center for Nebius and Microsoft to utilize.
And it is your understanding that that makes you a public utility?
Under the Vineland definition, yes.
No. I just want to make it known, I guess put this on the record. I had previously sent out an email very clearly spelling this out, citing different case law, which I don't want to belabor the point, but I would recommend the planning board taking a look at that. I believe it was sent to you, zoning staff, planning staff, city council, as well as the construction officials for the city. What about business office?
Okay, what about it?
Are you maintaining that that is one of the uses that you're planning?
That's what the professional planner testified to this evening. And he also testified that the power plant was also an accessory use. So whether it's principal or accessory, it doesn't really matter.
Okay, but we need a principal use, no?
Yes, correct, in order to have an accessory.
All right, so business office is defined as any office other than a service, whatever, medical office, rendering services on a fee or contract basis. So we then have to look at the definition of an office per the city municipal code. An office is defined as any room or group of rooms used for conducting the affairs of a business, profession, service, industry, or government. I want to note this last part of the definition here. For purposes of this chapter, if a use established on a property has an on-site office that only serves the use established on that lot, and that is clearly subservient to the use established on that lot, said office shall not be considered a separate use. Just want to point that out for the planning board. All right, what about printing and publishing as a use?
What's the question?
Are you claiming it's a use?
The professional planner, you heard the testimony.
Okay. I think this one's pretty obvious, common sense understanding of what printing and publishing is. Storing data for, something like Microsoft to run Copilot, to share information internally, does not constitute printing or publishing. Printing or publishing implies that you're putting that out to the public in some capacity. All right, so I want to address the claim that the land use had already been approved by zoning. Was that your understanding, Mr. Freilinger?
That's correct.
Okay, and when did that take place?
I believe the zoning officer's letter is February 21, 2024.
That's correct.
Okay. And what specific use was deemed appropriate by the zoning officer?
Wasn't a specific use. The data center use that was described in the letter was deemed a permitted use.
Just data center use broadly?
Data center use, yes. I think he indicates in his letter as it was described.
Okay. I also have a question, just, it's been a minute since I've done engineering here, but how is it that the estimate remains 300 megawatts, which I believe came from the June 2025 application, despite the fact that the building footprint has been diminished significantly?
It has been diminished significantly since when? The initial application for this application was the same size building which indicated the 300 megawatts. Prior to that time, there was actually, on the approved site plan, there are 2 data center buildings that are larger than this particular building, which could have had up to whatever megawatts if it could have been available on site. But it's not available on site. The 300 megawatts is what's available on site. So this data center building was actually made smaller for the 300 megawatts.
Yes, but when the 300 megawatts were initially proposed, that was not for the same footprint that we have currently in the site plan?
I believe it is the same footprint, yes.
All right.
That would be with the Bergen engine site plan.
Okay. Is it your understanding, or would you claim that Vineland residents are not going to be responsible for subsidizing the water usage of the data center?
That's correct. They're not going to subsidize anything of the data center. And I know there was a question that had come up, I think the last hearing, and I'd like to address it now, about the 5 megawatts of electricity that's being received from the city of Vineland. That's not being subsidized by anyone either. The project itself pays for any connection that has to take place. There are no upgrades that were necessary, and they actually, pay their monthly electric bill. And there's, with the rate associated with it. So that gets money to the city of Vineland the same way as the water utility. Instead of doing their own well, they're actually going to be paying the city for the water.
Are you aware that Vineland residents already subsidize commercial and industrial water usage?
I do not know that.
Okay. I just want to briefly explain for anyone who hasn't taken a look at our municipal code and the water rates. I would recommend that you do so. It's kind of interesting. So users pay a lower rate per gallon the more that they use. So effectively, we are encouraging commercial and industrial users to use as much water as they want to. Drive their rates per gallon down. We also have this thing called a water cost recovery clause. Essentially, when the cost of operation for the water utility increases, they can increase your cost per gallon. Previously, I think it was about 44 cents per 1,000 gallons when they decided to implement this, or at least up to that. City Council has now taken away that limit, so they can increase it to whatever, essentially, whatever's necessary. So effectively, I don't want to just pin this on the data center, but for any commercial or industrial user, if they are increasing the cost of operation for the water utility, our rates are going to go up. Now, we are already paying more per gallon than these commercial and industrial users, so I know that this is not something to ask the planning board directly, but I just want to encourage everyone here to consider if maybe we should amend our municipal code to create separate designations for residential consumers, commercial consumers, and industrial consumers to guarantee that our rate per gallon is not being hiked up because of these additional uses here. I just want to conclude here by saying that from the start of this project, there's been a clear lack of transparency. I just want to say on the record how patronized I feel by Data One, specifically the offer for the vertical gardening project, going in an agricultural hub in a rezoned agricultural zone. It's a slap in the face, frankly. And if you want to make it worth our while, frankly, I would say nothing less of public control and public ownership is what I would ask for. But a CBA, I'll take a CBA. Community benefits agreement. I'm just tired of greedy corporations trying to bully the little guy. We may not be a wealthy municipality, but we're scrappy, we stay informed, we care about our community, we care about each other. Data One, I think, thinks that they can pull the wool over our eyes, and I just want to say for the record that you cannot. So.
Thank you. Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth this evening?
I do.
Please state your full name and address for the record.
Roger Merle, M-E-R-L-E, 159 Defiance Road, Malaga, New Jersey, 08328. I was kind of taken aback to hear that this project is not getting subsidies. I seem to recall that when they ran out of that, when they needed 2 more cranes, they took a loan from the city of Vineland. This is a corporation that allegedly capitalized at $17 billion, and they needed $6 million from the city of Vineland. That tells me they are not on financial solid ground.
They did apply for that, but that was not, it wasn't granted by the council. That's right.
No, that's not correct. It was granted, but I believe they
Correct. We were
rescinded their request.
the project was requested by the city to ask for that loan because it was a 1-year loan in which the city would have received about $400,000 in interest for us paying it back in 1 year. But with the, when the project was hearing some of the anger from community members, they told the city that they would not take the money. They did not need the money for the cranes. It was a way to get the money. It was a way to get $400,000 to the city within a 1-year time frame.
Make a donation.
Be that as it may, I'm doubtful. On the other hand, I am given to understand the property tax structure that for the first 5 years, they pay nothing. Absolutely nothing.
That's not before this board. Anything they're paying in taxes, whatever agreement they
I understand it's not in purview of the planning board, but the planning board is supposed to look ahead. And by ahead, I mean more than just what's before us right now, this moment. You have to think longer term. And by longer term, I mean, again, getting back to property taxes, 5 years worth, nothing is paid. In the 6th year, they pay 5% of assessment. They do that for 20 years before they're paying 100%. How do we, as homeowners or property buyers, get a deal like that? We don't.
Mr. Boucher,
Can I respond to that, please?
Yes.
That is completely inaccurate, what you're indicating. The tax agreement that's in place is the standard New Jersey pilot agreement, which is a payment in lieu of tax. It's a 5-year abatement process. Most of the money during the abatement process goes to the city of Vineland. The first year, after receiving a CO, it's zero for improvements, not for the land. The land is taxed and all of that money gets paid to the city. But the improvements that are placed on that land, the first year is zero, the second year is 20%, 40% the third year, 60% the fourth year, 80% the fifth year, and 100% in year 6. In year 6 is when the regular tax kicks in and the county and everybody else draws a much higher share. So in the first 5 years, the city of Vineland gets a lot of the tax dollars associated with the pilot program. That's it. That's the only tax program that's in place for this project. There is no long-term tax program.
Okay, I was under the impression from what I've read in the media that was the way it is. If it's what it is, I will stand corrected.
There was the ability to obtain a long-term tax agreement for the project. This property is in a redevelopment area. Under redevelopment law, the project would have been entitled to a long-term tax abatement / exemption under New Jersey law. The project chose not to do that because those types of the long-term agreements, they potentially can have a negative impact on a municipality. We don't really think so, but they potentially can. The 5-year abatement program is tremendous for a municipality.
All right. That said, one thing that, again, thinking longer term here, there is nobody on the stage or in this audience who can guarantee that any data center in this country or on the planet is going to be in business 5 minutes from now or 5 years from now. In the past year and a half, over 500 data centers that are under construction on the planning board, operating to some degree, have curtailed or canceled or gone out of business, losing a capitalization of over $1 trillion. This is a Ponzi scheme. This is a scam. It's being financed primarily by Bitcoin. What is Bitcoin? Nothing. There are actual, real, legitimate banks that are pulling out billions of dollars in investment. This is a castle built on quicksand. And in a matter, I think, short matter of time, this country is going to be inundated with defunct data centers that are going to have environmental problems and all sorts of other legal issues. And as a planning board, you really do have to think further ahead than what the piece of paper in front of you is all about. Thank you.
Thank you, Mr. Ross.
Can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth this evening?
Yes, I do.
Please state your full name and address for the record. And closer to the mic.
My first name is Gail. My last name is Lindsay. 1207 Gary Avenue, Vineland, New Jersey. 08361-7225. Good evening, gentlemen, ladies. Thank you for letting me talk. Allow additional work to be completed at Data One Nebius Data Farm in Vineland, New Jersey, built on a former sand plant mining. At one time, glass houses flourished in Millville and Bridgeton areas. Weekends, Kirk Glass, Conti's, Anchor Hockey, an era bygone. Only used for sand is for golf courses, which is a specialized grit, extracted only from certain places. This land is desolate, unzonable for home building, unable to pass even a perk test. But perfect for a data center. Data centers from New York to Pennsylvania will not be bogged down by traveling down south speed. It matters, you have a throughput. Built on the Kirkland-Cohansey Aquifer, the amount of water to cool the racks is equivalent to the usage of 7 Olympic swimming pools. Then this is to be recirculated through chillers. Some evaporative segments will also be adjusted to limit the escape. The cooling of bare metal, as they call it in the virtual computing industry, is the usage of virtual computers dividing up to look as many, but one for each customer. They buy the resources of the virtual machines, 128 gigabytes of memory, 1 terabyte hard drive space, and 432 gigabyte for memory, shared memories, and 250 gigabyte microprocessors. Each customer gets a portion. Vineland has its own electric plant. Natural gas power, instead of using Vineland grid for 350 to 350 megawatt facility, needing a natural gas storage tank to turn natural gas into electricity on site generation instead of pulling from Vineland or Exelon's grid. You're utilizing Bloom Corporation's fuel cells, which are quieter than combustion engines. Nebius Data One will give back to the community through education cooperative classes through Rowing College. They will also help by creating indoor food farming in the future to help with the famed nickname of New Jersey, being the Garden State. Look in the mirror. Look at yourselves. Cars replace horses for transportation. ICs replace tubes in the ENIAC and in our TVs. Phones were PTT analog switching networks replaced with handheld computers that we call our phones. Ask the question. AI will be the answer to your question and to the world. We are advancing. Can you put your phone down? No, you cannot. Can you solve complex problems by hand like we did in college with differential equations? Yes. AI can do it in minutes. Okay. Compare and contrast the complex systems in hours instead of days. This is our future.
Do not let it fail. The future is here. Please embrace it. Thank you very much.
Thank you, Ms. Lindsay.
Have fun helping lice.
Okay. Thank you. Do you swear to tell the truth, the whole truth, and nothing but the truth this evening?
I do.
Please state your full name and address for the record.
My name is Jesse Nazario. That's Nazario with an N, not Rosario. Everybody gets that wrong. I live at 1149 Ray Drive in Vineland, New Jersey. I was born, raised, I've lived in Vineland my entire life. I love this town. It's the greatest town on earth. That's not an opinion, that's fact. I tell anybody that when they say, I can't wait to leave Jersey, I'm like, you haven't lived anywhere else because this is the greatest state ever. So I'm asking you to let it continue to be the greatest town and continue to be the greatest state. AI centers are not making money. They're not. They're not doing anything. It's a promise for a future that doesn't exist. Let's invest in things that actually are here and that matter right now. The only thing that came positive out of this data center, as in 20 years, finally me and my mother-in-law agree on something. We both don't want it. That's it. Thank you.
Thank you, Mr.
Can you please raise your right hand?
Yes.
Do you swear to tell the truth, the whole truth, and nothing but the truth this evening?
So help me God.
Please state your full name and address for the record.
Nicholas Messiano, 752 Gershel Avenue. You guys like my new hat? Excuse my clothes, I was at the farm all day. And it was really hot and dirty. My name is Nicholas Messiano. I live in Pittsburgh, and Vineland has been my home city, the big city, for most of my entire life. Very recently, I was a professional corporate programmer. Does anybody in the audience know who Kylie Jenner is? Does anyone know Kylie? So I was selected out of 800,000 employees to program her clothing website. It was me and a team, of 3 people, and I programmed Kylie Jenner's clothing website, partially sitting in the Starbucks on Landis Avenue. How about that? But with that, I can confidently say that I have more computer swag than anyone from Nebius who may have walked in the door tonight. I understand Vineland wants to boost tech, and I believe it's a noble cause. But now, Mr. Solicitor, I'm going to go into my opinion a little bit here. And nothing here I say is personally. You know, I like everybody here in Vineland. I think you guys are great, but just let it rip here for a second. And let me just start off with, I'm most annoyed that the talents of Freilinger and John Ruga are being used to build a giant gaming PC. Of all the infrastructure we need, and all the brain power, and a massive concrete fabrication, we're building a big gaming PC. AI data centers are no more than a tactic to pump and dump tech stocks, and in effect, steal pension funds, 401ks. They hide behind the mask of technology. I was at the top of the corporate programming game. I saw the code. All of the supporters who are in the live chat are talking about how rich they're going to get off the Nebius stock. It's a pump and dump stock scheme to rob pensions and investment accounts, and that's all this is designed to do. I've seen the code. AI is in the exact same vein as the sketchy crypto bros, the empty warehouses in Piles Grove, the blood of Dollar Generals, and whatever they call it next. If Vineland wants to boost tech, and I hope you do, to attract people like me, I read the articles you guys talking about it, I think it's cool, and to keep your sons and daughters and grandchildren living here, you need to focus on the infrastructure to improve the quality of life, the walkability of the city. That means safe, walkable roads and areas. They're building a train that goes to Philly, to Glassboro. The next phase is to come here And after that, we're going to need to build a whole bunch of trolley lines. That's the infrastructure we're talking about. Instead of everybody fighting over a French guy's gaming PC, getting all of us angry at Freilinger and all these people that do things, we need to focus on building the infrastructure that we need. We need to get everyone on board with that. And I want everybody to write this down right now. It's very, very important, especially the Vineland Planning Board, Mr. Ruga, and you, Mr. Freilinger. It's finfrock.com. 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 That is the pattern of development that this world needs right now. It is, look it up, you'll get it, okay? We're going to be at the next, in the future, we'll be at one of these doing that. And everybody will be cheering for you. So anyway, let me just, I'll end this. If I was in charge, I would take all these AI pension robbers and fake AI programmers, I would reassign them to work in a machine shop. Their new jobs will be cutting steel and welding, so we can build the trolleys and the train lines that this world actually needs. I was told at my corporate programming job, at the top of a brand new skyscraper in Manhattan, that I can have anything that I want in the world. And do you know what I did? I quit. And I spend my time now on a piece of crap farm in Pittsgrove, and I might spend my time here in Vineland because this is paradise to me.
Do you swear to tell the truth, the whole truth, and nothing but the truth this evening?
I do.
Please state your full name and address for the record.
Danielle Paz, and my address is 443 South 6th Avenue, Galloway, New Jersey. I'm an environmental advocate, which the environment also affects people, in South Jersey, and I have family. I grew up actually in Vineland, in a small rural township right outside, so we relied on groceries, retail, restaurants, everything, because there was not very much in the rural township that I grew up in, Deerfield Township. So our groceries were here. I went to 2 private schools in Vineland and a dance school too. So I'm very familiar with Vineland. This data center affects my family as well as me because we all share the same aquifer. I just want to read the definition, even though I know you guys know what the purpose of the planning board is. I'm going to read a portion of the purpose, which, not the beginning, which I know you guys know about land use. And it ensures that new buildings, subdivisions, infrastructure projects promote public health, safety, and general welfare while balancing economic needs with environmental protection and community values. And I've attended a couple meetings, the last one via live stream, thanks to a group that's right here that live streamed so I could see it from Galloway, New Jersey. That I haven't heard, and I hear a lot, and I'm like I said, an environmental advocate, and not a lot about, so this question's going to go to the planning board, about the economic impact, like environmental impact study, economic impact study, not how it affects businesses like restaurants that depend on water, schools that depend on water, hospitals that depend on water, farms, and like you said, food production that depends on water, and the real estate market, how it would affect it. So I would want to ask the board, have you done an economic impact study on how this data center is going to affect your businesses if they should not be able to operate, and small businesses will be affected as well as.
Since you directed it to the planning board, I'll try to answer your question. And the basic answer to that is the planning board doesn't look at economics. We're not charged to look at economics. For example, if a developer comes in to build houses in a neighborhood, and a lot of times people will ask us, well, what are they selling them for? That's not for us.
Exactly.
We have to make sure that they follow the law, the rules and ordinances of our city to make sure that it works.
Right.
How much money it generates or what it does to other businesses?
That's not what I asked. I asked about the water usage.
Well, even that.
So actually,
That's what we look at there is our water utility allows for, they give us their opinion on what the usage should be, how much it should be, and we go by what they're telling us as far as how much water usage any business could do.
Okay, so I did ask about did the city and the planning board mean including it together because I understand the purpose of the planning board. And I've actually been involved in passing ordinances at the local level, so I am real familiar with the process. So how does one resident here request an economic impact study by the city to and businesses? How do they request that to be done by the city? And the definition as I read it said balances the economic needs, environmental protection, and community values. So how does one, because I had not heard about that up to this point.
It wasn't a requirement for the applicant, so again, they can't be forced to do one.
Well, I mean, so the public can't ask, the businesses can't ask for economic impact as far as you know?
No.
Okay. The second question goes to the planning board and the attorney representing the company for Data One. Retail use. Are you aware that New Jersey passed a new law and it went called the Fair Price Protection Act?
I'm sorry, can you say that again? The what?
Are you aware that New Jersey just passed a law called the Fair Price Protection Act?
The Fair Price Protection Act?
Yes.
No, I was not aware.
As does the planning board. Are you aware that the New Jersey just passed in the state legislature this spring a law called the Fair Price Protection Act?
I'm aware of the new law that was just passed related to data centers and their usage of power, yes.
Is this one that has nothing to do with the usage of power? This has to do with retail. This has to do with surveillance pricing. This has to do with manipulating prices in the public from data mining the public that's in the area. So this actually went into effect already in August 1st. So how is, for both, this question's for both of you, since you both, how is Data One going to protect the consumers here, that live here, residents? It's enforced by the Attorney General, this law. The fine is $10,000 on the first offense and up to subsequent 20,000 fines for subsequent offenses. How is the city going to protect the public by making sure that Data One adheres to this law? With retail use.
Okay, how are they, well, I guess how would the law impact that?
Because they're not allowed to do surveillance pricing using AI data centers.
Again, if there's an issue, I think you answered it, the Attorney General would enforce it.
Yeah, but how is the Data One going to be, are you going to make sure they're not doing it?
Well,
we don't police every business on whether or not they violate, whether it's a Consumer
Data
Fraud
One,
Act or
okay.
pricing. That's why you have the Attorney General. Any consumer can make a complaint to the
Data
Attorney
One,
General.
can you answer that question?
Well,
You're the one.
each entity, no matter who they are, has to comply with the law, and if they don't, Mr. Malinsky's correct.
But, all right,
The
well,
Attorney General is the enforcer of the law.
well, you weren't aware of the law as of right now. You're going to.
Well, I'm not the corporate attorney for that one. I'm the land use lawyer.
This is going to be voted on tonight, and I'm not seeing any that you're even in.
How is this law related to their use of the municipal land use law?
Yeah.
Not the municipal land use, it has to do with the retail use.
But the board only can consider the municipal land use law.
Excuse me.
So again,
Retail,
how does this,
the retail,
excuse me, one of us going to, how does this use affect the municipal land use law?
Because it's retail use, and that's what they're doing. As someone said before, the attorney said before, how in this retail use or the business office, in the nitty-gritty details of what you're actually doing. The person that came up here that was the planner actually said that what it's actually doing is applicable to the planning board. And that is what they're going to be doing. If they're going to be doing surveillance processing against the law. Surveillance pricing.
Again, I guess what we're trying to say is, with any application that's in front of us, we approve it based on land use law. If that company goes and violates the law, We certainly don't enforce that. And again, as
I-
Mr. Fralinger is saying, he is a land use attorney. He's not their corporate lawyer.
Well, but the use is retail use, and it fits underneath that.
Again, you're citing statutes that are enforcing aspects of a retail use, but don't necessarily have any application to the municipal land use law and the statutes that this board has to consider when reviewing this application.
Well, retail use is under there, that's why I was thinking.
Again, retail is a use, and if it's something applicable, and there's retail uses throughout the municipality, and if there's something applicable to the municipal land use law to that use, then yes, that this board can consider it. But the statute you're referencing has no bearing on the municipal land use law. It's an enforcement statute if they violate some aspect of their retail operation and can be enforced by the Attorney General. But again, it doesn't come into any consideration under whether or not they've satisfied their proofs under the municipal land use law to be entitled to preliminary and final major site plan approval.
Okay, I'm just pointing out that the attorney did not know the law, and that he doesn't have a plan.
It's recognized.
So point number 3 is about LNG tank trucks, and I know that in the previous meeting you were hearing information about that. Actually was on a coalition of environmental nonprofits that stopped the LNG terminal out in Gibson, New Jersey. So I'm very familiar with the dangers that are involved in doing campaigns to stop that port. So my question is to the planning board: are you aware, or do you know, if an LNG tank truck were to explode, they're highly volatile to a cloud, what is the evacuation radius that you would have to evacuate the public? I think the fire marshal, you said, had a list of concerns. So has that been addressed yet? What would be the evacuation radius for that?
Okay, as we said earlier, the list is not necessarily a concern list. It's a list of documents that have to be provided to the fire marshal. As of any conversations with the fire department, they have no concerns with the LNG. Mr. Fralinger, I'm going to ask, because I had this for later, but there's been talk about how many trailers of LNG gas are coming in, because the LNG gas, the way we were told previously, is it's there as a reservoir if needed, if the gas.
That's correct. And I guess there's a little misconception behind what it actually is. I heard it a little earlier today as well. During the last hearing, I indicated that we receive, or the project's going to receive, both firm and interruptible gas service from South Jersey Gas. Firm service is basically guaranteed. There's a large portion of the service that is interruptible. And what that means is that South Jersey Gas, during periods of high demand or during maintenance or anything like that, can shut off gas to the project, the interruptible portion. The interruptible term that South Jersey Gas has provided to the project is 10 days. Now that doesn't mean it's going to be shut off for 10 days in a row. It's 10 days per year is what gas could be interrupted, but only the portion that is interruptible, which is a large portion. And I think that's probably one of the misconceptions with the BPU application, which we didn't file. South Jersey Gas filed that. And I skimmed through it real quick. It's actually the first time that I've seen it. But I did see where it indicated 125 megawatts of firm capacity. Well, that's not the entire amount of gas that will be received by the project. It'll be enough for these 300 megawatts. So the amount of trucks that will be coming to the property, well, in the beginning, we have to fill the tank. And then once that tank is full, it only gets used during an interruptible period. It could be 6 hours. It could be up to 10 days. During that time, the tank would get filled by trailers. The other 355 days of the year, not filled by trailers, except for any evaporative loss or blow off or something like that. You would have a truck come in every once in a while
to fill that back up. Because what happens is as the gas, as Mr. Raymond testified to the last hearing, what is always attempting to happen with this gas is it's attempting to vaporize because it reaches its boiling point and it wants to become a gas. That gas is captured and it's actually taken into the system. It's not let out into the atmosphere. It's taken into the system and actually utilized by the project, that gas. But then you have to replenish it. And whether that's once a month or every 3 weeks or 6 weeks or something like that, a trailer would come in to replenish the tank. The truck traffic at this facility is minimal and will be minimal, not only with LNG, but with any trucks coming to the facility. I think the testimony was trucks coming to the facility, maybe a couple trucks a week. And from what I understand, that was a very conservative number, a couple trucks a week. And if you remember, and I know this board does remember, that this property, along with the northeast property, is all in the Energy and Minerals redevelopment area. As part of that entire project, the road network was redone from 55 to this property. Burns Avenue was put in, the state put in a traffic light at the 55 overpass. All of that was done for truck traffic. Not only for the Northeast Precast site, but for this site, because I'm sure this board remembers, there was the potential for this property in the past to have large-scale warehousing on it and distribution. And there would have been a ton of trucks that were going to be going from this property to 55. Now, I know there was a question before about last hearing about what road network is going to be utilized by trucks coming to the property. Well, obviously, we don't know, but what we can say is that what would make sense, 55, Sherman Avenue, Lincoln Avenue, they're the roads that will get used by trucks, and that's where the trucks use now, not the side roads for trucks. That Burns Avenue bypass that was put in is phenomenal. It works great for the trailer traffic that's coming out of the property, and that'll continue into the future.
Okay, so about two trucks a week, you're saying 2 to 3 trucks a week?
That's a conservative number. It's probably going to be less than that, but yes, we'll say 2 trucks a week.
Okay. So to answer my question, because it wasn't answered.
Not all LNG tanks, though. Not LNG trucks.
So to answer my question, because it wasn't answered, is that the evacuation radius for glass is 1 mile to up to 2 miles, and also the fire along the route. The firemen need to be specially trained to respond to that fire. It is way different, this explosion, than any other type of fire that they handle on a day-to-day basis. And I would like to also say, as of 6:25 today, in Glenpool, Oklahoma, there are 2 LNG tankers on fire that responders were doing, and they couldn't put out the fire to one, and then one fire led to the 3rd tanker getting on fire. So as of today, 3 LNG tankers were on fire. As I was sitting here just looking at looking up information. So that is, you can look it up. So it is very possible. It is not something to downplay. And you can look at also news in the past, because I said I've worked on this issue before, and there has been explosions with tank trucks. So I'm going to finish here is that I've just proved the point that a lot of the questions that are going to affect this project are unanswered, not answered, and I have to answer them. So I think that this would be not right for this planning board to move forward with this project until they are fully informed of all the information that's involved with this project that's going to not just impact your city, surrounding cities and the whole aquifer. Thank you.
Thank you.
Hello, my name is Ramon Mora Jr.
Can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth this evening?
I do.
Please state your full name and address for the record again.
Yeah, my name is Ramon Mora Jr. I live on Elmer Road in Vineland. What was that?
Can you talk slower and say your name and address again?
Sure. My name is Ramon Mora Jr. I live on Elmer Road in Vineland.
If I start generating enough power on my residential property to power Vineland, but the main use of the property is living there, will that now be allowed under zoning laws to maintain it as a residential property because the generators are an accessory use to the building and the primary use is what really matters? Yes or no?
I don't know how residential.
No, again, it depends on what zone you're in. Not every zone allows what constitutes an accessory use, or again, of a public utility, or in this case, even a second primary use as a public utility. So, not necessarily.
Okay. The use of a facility matters when you're talking about an industrial. If I build a metalworks facility in my backyard, or to build sewing needles or something like that, it's a little different than an arms manufacturer, if you ask me. There's no business office that I'm aware of, as the previous planner had mentioned, that this is a business office, that will generate 2 times the amount of the city's electricity and put a strain on our overall utility grid. That's not a business office. In my opinion, the planning expert's testimony tonight should be stricken from the record if he's conflating data centers with generative AI hyper data centers. They're not the same thing. A business office is not the same thing as an industrial plant. I can't even get chickens on my property because I fall roughly about 5 feet too short without spending thousands of dollars going before the board, applying for variances, and yet zoning map discrepancies for conglomerates are allowed to be ignored, shrugged off, not paid attention to. I urge you to use more scrutiny to this monstrosity than you do my want to own some chickens. If this facility is an AI factory for processing, and it's processing nefarious data, like surveillance state objectives data, can we now not ban surveillance state cameras in Vineland because we would subject our city to a lawsuit because they're using it to power data, surveillance state cameras? I'll pause for that question.
If the board were to go forward and approve the data center usage, they wouldn't be liable for anything related to the operation of that data center.
Okay. It should be considered that the use of this property will amount to an extreme rise in CO2 emissions in the local area. That risks increasing local asthma cases and does not seem like it aligns with protecting Vineland's health. Given that our only hospital right now for the county is currently at risk for closing due to funding cuts from this administration, can we not do something about protecting the health of our Vineland citizens? Rhetorical. In closing, while attending a planning board meeting earlier this year, a member that sits on stage today in Hamilton, New Jersey, on record, on an official capacity, stated in his professional opinion that if it is not an explicitly permitted use in response to the data centers, that it is not an approved use and therefore not permitted. If that person holds the same ideology today, I believe that is a conflict of interest to be on the board or sitting up there today giving advice on this project. That's all.
That'd be 1 second. Hold on 1 second.
I'm going to address that real quick. What Mr. Moore is speaking about is that I am the solicitor for the town of Hamilton. And in my capacity as a solicitor for the town of Hamilton, and I will say this, Mr. Wendt provided GRESS 7, which had Hamilton's land use ordinance on it. And Hamilton's land use ordinance is different than Vineland's land use ordinance. Hamilton's land use ordinance specifically states where this chapter is silent as to the allowance of a use in a zone district, such silence shall be interpreted to mean that the use is not permitted. A use is not permitted in any zone district of the town unless specifically included as a use or category of use in this chapter and in the specific zone district. Hamilton's a little different also because it's a complete Vineland's town. So Hamilton's ordinances were different than the city of Vineland's to address that question.
May I have you raise your right hand, please?
Do you swear to tell the truth, the whole truth, and nothing but the truth this evening?
I do.
Please state your full name and address for the record.
Kimberly Gregg, 1416 14th Avenue in Dorothy.
Thank you.
Bye.
I just want to point out, the city of Vineland is drawing its water out of the Kirkwood-Cohansey aquifer, correct? There's 1 million people that count on the water from that aquifer. It covers 3,000 square geographic miles in the state of New Jersey. With this amount of water being pulled out of it for this data center and the others that are being proposed around the state, the water's gonna run out. It's already happening in Virginia, it's already happening in Georgia, where people are getting brown water out of their spigots. Who's protecting us that have lived here? I've lived in Atlantic County my entire life. I've been in Dorothy for 35 years. And I have no option other than my well for water for myself and my small amount of animals that I have on my property. Nobody's worried about protecting all of us that have to draw water from the aquifer while these big corporations are going to be pulling it all out of there. And then we're left with nothing that's even drinkable anymore. It's happening around the country. Who's protecting us? Can you answer that for me? Why can't the data center truck in whatever water they need rather than pulling it out of our aquifer that over 1 million people rely on for their drinking water? And the 200,000 acres of farmland that is growing food for all the people in New Jersey and South Jersey. Who's protecting that? We're going to lose our food source if that aquifer goes dry. We're going to lose our drinking water for over 1 million people. Nobody's worried about protecting us in that. And it's happening around the country in other places where they turn their faucet and they're getting brown water out of it. That scares me to death. Can you answer that for me?
Well, Ryan, you can correct me if I'm wrong, but municipalities are issued water allocation permits from the NJDEP. And,
correct.
And each municipality has a certain amount of water that it can utilize out of the aquifer. Their usage, as already stated earlier, is minimal compared to other industrial uses within the municipality and is within our water allocation permit. Their usage doesn't even bring Vineland close to the amount of their water allocation limits at all.
Additionally, I believe the most recent letter from the water utility director indicated that the city would reserve the right to prioritize residents in times of drought over this data center.
We're already considered in a drought and have been for over 2 years. This makes no sense that you're going to allow a corporation to come in and deplete us more. There was a story on CBS News a couple of weeks ago that showed that for our water levels to get to normal, we need at least 20 inches of rain around here in a 2-month period to bring our water tables up to normal. That's a lot of rain that we're not anywhere near close to getting. Like I said, this is scaring me because if I lose my well, I lose my property, I lose my home, I lose my animals. I can't survive without my well. And that scares me. And I don't hear anybody saying, is this company going to be able to be held responsible when that happens? Because it's happening everywhere else. It's happening. And you can't ignore that fact.
again, I get your passion for it. We look at the water usage level for this application from our own city, who has the solicitor said, has amount of water that's given to them from the DEP, and it's within the limits that the applicant is allowed to use. I mean, I get your plight, I understand that. I don't know what happens in other communities. We can look at this one and only base what we're looking at on what their application says and what our own city water utility is saying. One of the things that came out of one of the meetings was people from the audience saying, what happens when there's a drought? Are they going to get the water and not us? We now have our water utility telling us that's not going to be the case. The citizens will get it, and it's also why they have a 28 million gallon tank, so that in case that happens, they can continue to operate and the citizens can still get their water. So I do believe that some people are looking at that, and that's why some of these things are being done.
Isn't that 28 million gallon tank going to be filled out of the aquifer?
It's coming from the city's water supply,
Which
and
comes
it's
out-
not going to be all
which
at one
comes out
time.
of the aquifer.
It's not going to be filled all at one time.
How long is it going to take to fill that?
That's between the applicant and the water utility.
They have to get approval from the water utility, so the water utility is going to make that determination.
Okay, thank you.
Can you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth this evening?
I do.
Please state your full name and address for the record.
Andrea Lamb, 2412, is it echoing? 2412 South Main Road, Vineland, New Jersey, 08360. And I've been a landowner in Vineland for 40 years. I won't be long, I just have 3 things to say. Mr. Freilinger, this mitigation wall that's going to be built, how tall is that wall?
35 feet.
35 feet. Engineers, how tall is 35 feet? Is it from the floor to the ceiling? Is it a 3-story building?
I mean, it's just about a 3-story building. I mean, this is, from
It's
the floor to there is probably pretty close to 35 feet.
But you also said a 3-story building.
Right.
It's tall. Either way, it's tall. So in the middle of South Vineland, in the middle of homes, farms, schools, we're going to have a 35-foot wall sticking up in the air. Correct.
Yes, it'll be about 20 feet shorter than the building, and it'll be behind a berm, which is 14 feet high, which is going to have 12 to 14-foot trees on it.
Okay, and it will still be 35 feet high.
That's correct.
That's the only point I wanted to make. Then the second thing I just wanted to say is for anyone here who is not familiar with the Pannoni report and the report from the Vineland Environmental Commission, I just urge you to check those reports because both of those reports found many problems with the Phase 2 proposal here tonight. The third thing I wanted to say is just I urge you to vote no to this large LNG storage tank. Mr. Freilinger, did you just say a few minutes ago you're getting your gas from 2 agreements you have with South Jersey Gas, one firm and one not firm?
No. It's one agreement, and we're not getting our gas from South Jersey Gas.
I thought you just said you were.
South Jersey Gas is doing the transportation. We get transportation from South Jersey Gas. The commodity is actually being purchased from a third party so that we're not impacting any of the supply of South Jersey Gas. We're utilizing their pipeline.
Yeah, I understand. That's what you said the last meeting.
Correct.
That you were getting your gas from out of state.
Correct.
What state is that?
I believe it's Pennsylvania.
Pennsylvania, where they frack to get gas.
I have no idea whether this gas is from.
And
I just want to say, first of all, I just want to say that one tank on Lincoln Avenue, one gas truck on Lincoln Avenue is even too much. I know you say they'll be coming off 55 right into the plant, but Lincoln Avenue has a very bad traffic report history. Last week, or at the last meeting, Mr. Freelinger, you said that that tank was a solution to the problem. And I wondered what the problem was. And then you started explaining that the solution to the problem was you, Data One, transporting their gas through South Jersey gas pipes. Because South Jersey Gas would make, and I quote you, a lot of money by you doing that. So I'm not going to ask you why again that you need this 1 million gallon LNG tank, because I know you have a good reason that you can say, but I just don't buy it. I just don't buy it. So I would ask the board, the planning board, to vote no against the storage tank. The Bloom cells do not need stored gas. They get their gas directly from the gas lines. Thank you.
Yeah. Do you swear to tell the truth, the whole truth, and nothing but the truth this evening?
I do.
Please state your full name and address for the record.
My name is Joganese Bolton Muller. I live at 2851 Palermo Avenue in Vineland, New Jersey. I am a born and raised Vineland resident. 51 years I've been in this town. I've seen a lot of changes out in East Vineland. I have literally stayed from Spring Road, Mays Road, to where I'm at now, just in those perimeters, moving as an adult. I've seen the changes in East Vineland, and the one thing I've heard all the concerns from everybody was about, the residents and things going, but I want to look at this at a different point of view, because this is what my profession does. I want to look at it at a standpoint for those students that are starting school this September. So let me just read this, and then if you have any questions. So I'm looking at this and concerns in twofold. The invisible environmental impact and the noise and the physical danger on our roads, especially when we have a school, 2 schools, 1 charter, 1 middle school, very close to this Data One Center. We really are unknown about what the effects are. I mean, this is all new. And it seems like all the time when there's something new, there's the what if, but we don't know. So my concerns are this. First, the residents living within a mile away from South Lincoln Avenue facility are already suffering from what they consider relentless low frequency hums, physical house vibrations. These 2 middle schools sit roughly 1 mile north of that exact same corridor. Acoustically low frequency sound waves travel long distances over flat terrain. If you've been out in East Vineland, it's flat terrain. On Palermo Avenue, I have sat in my backyard and thought, what is that noise? Got into my car with my husband, drove down Lincoln Avenue, and the noise is the data center's construction. So how is that going to work when our kids go back to school? Our sensitive kids that can hear noises that we can't always hear as adults. So what happens during that time? Now my second thing is those trucks. I get it, you said maybe 2, 3 trucks coming down, but you said Sherman Avenue. And you also said coming off of Burns Road 55. We have kids that walk, bus stops, and yes, activity buses that come from high schools that drop kids off that have to walk. And I have seen them walk down Lincoln Avenue to their houses, to the residents that are close by that Data One. So when your trucks come down there, even 1 or 2, have you been on Lincoln Avenue when the schools are getting out and it's backed up all the way down to Palermo? So how many kids are going to put to risk while they're walking down the road, maybe not even thinking about the trucks that are coming around at them? Are we going to think about that? That's important to me because I see these kids every day and I want to continue to see these kids.
I want to continue to see these kids have a wonderful environment in our Vineland public schools. I don't want them to have to worry about low humming and trucks coming after them on a small residential road. East Vineland was just that, a place where everybody tried to go out to because it got away from the noise and sound. We can hear the rifle range on Palermo Avenue from Mays Landing, so trust me, we all know in East Vineland, if the wind blows west just right, you can hear a lot of things. So don't think that when school starts, those kids aren't going to hear every bit of your construction. And when the construction stops, don't think that they're not going to hear every bit of that humming. Because if one person in this room hums, it doesn't really make a loud noise. But if everybody in this room hums, it's going to start resonating. And that's what's going to happen when we build all of that. I say, please, say no until you know all the answers. Are we going to put up maybe curfews when these trucks are going in so that it doesn't interfere with our kids' bus stops and pickups for parents? That way we know they're safe. Are we going to make it so that we have some maybe testing to hear if these kids are going to be hearing anything out in the playgrounds, in their classrooms, when their windows are open? Because again, these kids hear things that we as adults don't always hear. So I'm going to ask you. Now, Data One recently received a double stop work order in their installing major LNG and fuel cell energy and fluctuation and without municipal permits. I'm sorry. If our city has to tell you to stop doing something and you don't listen, what's going to happen when those trucks get on the road? Are they just going to be two, or are you not going to listen then? I would rather you be told what the new dynamics is going to be when the trucks go on the road, when they cannot, what the decibels can be and what they cannot. And the city of Vineland, if you're going to vote yes, you better hold them responsible. Our kids are in the waiting. They want answers. No kids are here. So as adults, we need to speak for them. That's all I have to say.
Thank you.
Hello.
Hello. Do you swear to tell the truth, the whole truth, and nothing but the truth this evening?
Yes, I do.
Please state your full name and address for the record.
My name is Gloria Donahue. I live in Port Lawrence.
Okay.
So I had a very similar concern, and I just wanted to reiterate for anyone that wasn't here at the last meeting, your acoustical specialist stood there and told us there were about 65 reports, noise reports, which, by the way, were not taken at the appropriate time. He also admitted to that. He said there were about 65 noise reports, and he read maybe 45 of them. Where is he saying?
What's the question?
I'm just letting everyone know that that's where we stand with your sound reports. They haven't even all been looked at.
They're not our sound reports. What do you
All right, the third-party acoustical specialist that Data One has contracted.
No.
Then what do you have to say about that?
They were sound reports that were generated by the county health department, which we were able to review.
But you didn't review them. Your acoustical specialist stood there and said he didn't even look at all of them.
He reviewed 40 to 45 of them that did not result in violations.
He didn't read them all.
Correct.
Correct, thank you.
Yes, the other 20 that also did not result in violations were not read. That's correct.
He also said something I found very condescending. He said, sound is a hard thing to visualize, which I don't think is true. I think that if you read all the reports from the health department, thank you for the update, there would probably be a pretty simple way to present that. I also heard from the Bloom representative that the fuel cells were comparable to a hairdryer. But that's one hairdryer and how many fuel cells. I just wanted everyone to know that. And also, you have a really great answer for everything. I'm from South Jersey. I'm fourth generation in South Jersey. One grandfather worked at a glass factory. A truant officer came. He was a kid. They hit him in a barrel. Luckily, things changed. We're not exploiting child labor anymore, but that's my South Jersey clout. I had to flex. My other grandfather grew tomatoes in Camden and sold them to the Campbell Soup Company. I'm very concerned with the health of South Jersey. I recreate in our waterways constantly. I'm very concerned with the health of the Kirkwood-Clancy Aquifer, which by some miracle is still considered one of the most pristine in our country. Despite the colossal amount of Superfund sites in New Jersey, I agree that's worth protecting. I'm not adding anything that hasn't already been said. I'll try to wrap this up. I think you have a really great answer for everything. I think that if this plan made sense for our community, we would support it. We're here to hear you out. We listened to 6 hours. We didn't even get to talk 2 weeks ago. It doesn't make sense. You're telling me the health department sound reports haven't been read. That's embarrassing for you.
That's not what he said.
That's what your acoustical specialist said there and said. He also said sound is hard to visualize. Sound is not hard to visualize. Do you think these people are stupid? Yes. Yes, you do. It's so apparent. You have the Bloom specialist giving us a really great pitch deck saying that it's a small amount of water, it's a small amount of water. What does a small amount of water mean to you? Say the amount. We're here to listen. Say the amount. She also said this is a well-established company. We have all of these really high-profile clients, and the fuel cells are very impressive, comparatively very energy efficient. I mean, it's amazing. Someone thought of that, invented it. I think that's great. But there's a thing about that is not forthcoming. It's not genuine. It's not giving the people informed consent. It's not giving the planning board informed consent, because then later on, only when pressed and questioned, she lets us know the next largest project by this well-established company. Everybody stay calm. We have so much, infrastructure in place to take care of this, and it's tested. The next largest one is about half the size, I think.
Quarter.
A quarter the size? Thank you. And not only that, do you think it's in Texas? Is it in California? It's in Korea. They don't know how to take care of this thing. That's all I really have to say, but please, everyone just know, their acoustical specialist stood up there 2 weeks ago and said they haven't read the reports. Oh, some of them might be a bird flapping by. They didn't take reports at 2 a.m., they didn't take reports at 4 a.m., they took them at 5 in the morning. We've been condescended to, talked down to. These people aren't stupid. And we also are here to learn. I'm here to learn. I sat through 6 hours. I learned a lot about LNG. Learned it's called LNG. There's a lot of contingencies in place. I understand the concern around that. I've also talked to some people in that field that say those contingencies are pretty fail-safe. I'm concerned about a lightning strike or a piece of space junk hitting the cryogenic storage of the LNG. Yes, I am. I'm concerned about all of that. But statistically, it's probably not going to happen. And I feel safe with that. I think we would all feel safe if we had all of the information and we were able to make an informed decision. So please, please, do not vote yes on this tonight. Please make an informed decision. You cannot make an informed decision when the reports have not even been read. Thank you.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth this evening? Please state your full name and address for the record.
Linda Sullivan, 609 Lanier Court in Williamstown. I'm here because we have something very close in Monroe Township. So I've been following you guys, and you guys came to our council meetings and helped us out. So coming here. But I feel like you guys are guinea pigs. You've been changing, it's constantly being changed, constantly changed. Looked into the Bloom fuel cells. The lawyer herself said the biggest, and I agree with what the woman just said, the biggest fuel cell building that they had built was like 80 megawatts. This was like 400. You're guinea pigs. They're using you. Everything's been changing. We're worried about the aquifer because it's close to the surface. It feeds all of South Jersey. Not only that, but cities have been sinking at 10 inches a year because of over-extracted water aquifers if they're mismanaged. All they're asking, and all I'm asking, because I'm part of that aquifer, is you have to watch the water. We're building South. New Jersey itself is so condensed with population, the populace. You need to watch everything. You guys are guinea pigs. I don't understand what's going on. You're gonna, 80 megawatts, she said, was the biggest building that they use these fuel cells. They have no idea how this is gonna work. Good luck, because I don't think it's gonna work.
Thank you for your comment. Thank you. Oh, I'm sorry. My apologies. I didn't know. I thought you were finished. If you're not finished, you can continue. My apologies. I thought you had finished.
I just had a quick point of clarification.
Ray, I'll give you a chance to.
Whatever, I just wanted to know that I just have that whenever you have the opportunity.
What's that?
Whatever the opportunity arises.
That's fine.
All right.
Seeing no one else from the audience, I'll entertain a motion to close the public hearing.
I did have one last thing I did go by the site when the data book was proposed to our area, and I came down to look and see what all this was all about. And it's farmland and residential areas. And then when I'm finding out this LNG tank going up 1.5 million gallons, what's the zoning for residential away from a 1.5 million LNG tank for residential property?
Good question.
What is it? Is it being your zoning? What
I'm
is
not
it?
saying what you're asking. You're asking what the zoning is
For a residential property to be next to a 1.5 million gallon LNG tank. If we can construct one. Can I construct one in my backyard?
No, this is in the industrial business zone. That's all they have to do is comply with the standards in the industrial business zone.
So we can have a property, somebody's property can be
Are you
right
in the
up against.
if it's in the industrial zone, they would apply for something that's allowed in the industrial zone. This is allowed in industrial. That's where industrial properties go, in the industrial zone. This is an industrial zone, and I will entertain a motion to close the public hearing.
No.
Second. So please raise your right hand.
Go ahead.
She's already been up there.
No. Do you swear to tell the truth, the whole truth, and nothing but the
Yes,
truth?
sir. Yes, sir.
Okay.
As you're saying, this is an industrial area. Yes, you have zoned it industrial, but all around it, within 200 feet, is agricultural, residential, and then we have school districts. So when you say this LPN is only on industrial land, will affect residential, commercial, agriculture. So I feel that that is being misled. This tank, I have someone who works within that industry, and they already told me it's very dangerous, and that's all I have to say.
Thank you. Motion to close the public hearing.
Second. Roll call.
Mr. Kasabian?
Yes.
Mr. Menz?
Yes.
Mr. Tobolski? Mr. Rio?
Yes.
Ms. Velez? Ms. Andrioli? Mr. Odorizzi?
Yes.
Dr. Arthur? Mr. Capuano?
Yes.
So, any other questions for the staff, board members? Any questions that you have? Any comments you'd like to make before we get to a vote on this application?
I'll give the opportunity to the applicant, counsel for the applicant, Mr. Wen, and either Ms. Bellevue or Mr. Parks to give a closing statement. You want to go first? No. Go ahead, Mr. Wen.
Thank you, members of the board. Long night again. I'll be quick. Again, my name is Ray Wentz with the Wet Law Firm. I want to clarify something that occurred in exchange during public comment, and then I just have a couple of things to read for me from the Cox legal treatise. I attached as Exhibit Reg 7 a side-by-side of the Hamilton Code and the Vineland Code. There was a suggestion made that maybe prior comments by a member of your professional team or yourselves regarding the Hamilton Code somehow created a conflict of interest for that individual. I disagree with that. I think it was a misstatement by the person who spoke as a part of the public comment, and I don't think there is a conflict of interest because of that. So I just want to make that clear. That's not the reason why I have it attached. I have it attached because your code does say at 425-269, no building or structure shall hereinafter be erected, moved, structurally altered, rebuilt, or enlarged, except as provided herein, nor shall any land be used for any purpose other than those allowable in each zoning district as designated herein, i.e., any use not enumerated in the applicable zone as a permitted use shall be prohibited. That mirrors the Hamilton language. So I'm going to disagree with the opinion to the contrary you may have heard. It's not enumerated as a permitted use, it's prohibited. So that's that. I just wanted to reiterate your jurisdiction and ability to deny this application. With just some examples from the Vernon Cox treatise, we all have it. And here are some examples of where site plan has been upheld by the courts and being denied. If it appears that no adequate water supply existed for the particular tract, a site plan could be denied on that basis. 2, fire safety is a factor which must always be considered by a municipal agency. 3, it is well established that if a site plan lacks specificity required by the ordinance, or the applicant fails or refuses to provide information pertinent to the plan may be denied on that basis. That's the Morris County Fairhouse versus Boonton Township, 228 NJ Super 365. There, the court rejected the applicant's contention that since the Department of Environmental Protection had exclusive authority over the issue, determining what repairs or modifications to a dam could be made, that somehow the board didn't have discretion to deny the plan. In fact, the court said you do. It doesn't matter if the NJDEP has jurisdiction at the same time. That's that overlapping jurisdiction I mentioned when I mentioned the bulkhead scenario down the shore. Another example, it's proper to deny a site plan because of the difficulty of providing safe access to the site. Because providing safe means of access to property is specifically required by the municipal land use law, and because the difficulty is directly related to the ingress and egress. That's the case of Lionel's Appliance Center versus CETA, 156 NJ Super 257 from 1978. The court held the planning board may deny a site plan application if the ingress and egress proposed by the plan creates an unsafe and inefficient vehicular traffic. Long story short is we definitely agree with the majority of the public comments. A lot of question marks. A lot of question marks. And that in and of itself gives you the power and really the obligation to say no tonight. I'm not going to belabor the point. Thank you very much.
Ms. Belby, Mr. Parks. Go ahead, Ms. Belby.
Good evening, everyone. I would like to take the time to thank you all for bearing with us over this last almost 12 hours of testimony and experts that you've heard. I'd like to thank this board for listening. I would like to thank the public for showing up and providing their point of view and for being patient with us as we put on expert and ask question after question. I'll also try to keep it brief. I just want to point out, like others have, there's a lot of questions left. Ms. Gardner, who I put up here, who was our last testimony from the SSJ side, she pointed out how she didn't trust Data One, she didn't trust this project, and there was a lot that was going to have to be done to win the public's trust. And I want you to think about that because I think a lot should be done to win your trust as the board. You've heard our questions directed at the different experts that Data One has put up. We've had questions about these fuel cells. about how they perform as a technology at this scale, about hazardous waste that they might create, about the disposal of that hazardous waste. We have questions about the CO2 emissions of these fuel cells technologies. We have questions about groundwater questions. We have groundwater molding questions. We have questions about how this plan was created and all the gaps in it. We have questions about even more than that. We have questions about the LNG tank. We had questions about all sorts of things, every aspect of this application. The EIS was woefully vague. There were so many gaps left, emissions that we don't know about, and we just would like this board to think about that when you're voting tonight, because there's too much left unanswered for you to conscientiously vote yes. And so I just want you to think about that as you're doing your vote tonight, and thank you for your time.
Mr. Fairlander. Okay, Mr. Parks. I thought you and Ms. Bellevue were representing the same client. It's okay. Go ahead. No, go ahead.
Thank you. I will be so very brief. I just want to point out the fact that there has been a plan that has gone before this board before. It has been approved. There have been stormwater issues. There's been a lawsuit that followed. It's been a problem for everyone. If it's the case that you can see that the stormwater plan isn't going to meet the state requirements, that is reason enough to vote no. Thank you.
Mr. Fairlander.
Thank you, Mr. Malinsky, and thank you, Mr. Vice Chairman, members of the board, staff, and thank you to everyone who's shown up the last couple of nights on this. As we all know, we're here seeking a preliminary and final major site plan approval. It's a second amended site plan approval. And the application that's before the board requires no variance relief in the IB zone, none. It requires very little waiver relief in the IB zone. Now, we spent a lot of time talking about different things. A lot of experts you've heard from talk about different things. You've heard about an LNG tank, and it was just mentioned again. You've heard a lot of expert testimony on that. LNG tanks are permitted in this area. You heard about potential risks because of trucks with the LNG tanks. Well, I mean, gas trucks go to Wawa every day. They go to Riggins every day. There's a heck of a lot of them that go. I pass them every single day on Lincoln Avenue. So yeah, that happens in this room. The question is do you comply with the regulations that the government has put in place in order to make sure that it's safe? And with the LNG tank, those regulations basically are the NFPA 59A standards. And you heard ample testimony how the design was in accordance with NFPA 59A standards. And then there's a secondary review on top of that, let alone an independent, I say an independent review. It gets designed by the maker. It gets, the balance of plant gets designed by an engineer. And then another engineer is brought in to review all of them to make sure that it's compliant with NFPA 59A. And after that happens, it's got to get reviewed by the local fire marshal. And there were questions about whether or not, Vineland's fire department could handle, some type of an LNG fire if that were to happen. Well, yes, Vineland's fire department has been trained in LNG. Those discussions have been ongoing with Vineland for, I've been involved with them for probably 8 months or a year or so. So yes, they are trained in LNG. Not that because it's this hazardous use, but because it is a use that can be utilized in the city of Vineland. So they would have to be trained on it. So the testimony that you heard, is for the health, the welfare, the safety. You heard testimony, a great deal of testimony with regard to water and water use. And we heard from some of the members of the public about, the concern with the aquifer. The testimony that you heard is, an average of 8 million gallons of water per year for the cooling system. Frankly, I've been involved in a lot of industrial projects. 8 million gallons of water is not a lot of water for an industrial project. And it is accurate when I stated that this project could drill a well and take up to 36 million gallons of water without a water allocation permit from the DEP. It's just a water use registration, and they'd be entitled to it, up to 36 million gallons. Now, do they want to do that? No. They want to give the money to the city of Vineland for the same water, and that's what they're going to do. So you heard about water, you heard about the LNG tank. Now let's talk a little bit about sound, because I understand. I really do. I understand the issue with sound. I don't live all that far from where this data center is. I'm probably 2 miles away from where this data center is. No, I don't hear it. And I listen for it, but I don't hear it. But I understand if people are hearing the construction that are going on. And the project is committed to sound mitigation. The project has to be in accordance with state law when it operates. It has to. It has to be in accordance with the New Jersey Department of Environmental Protection regulations on sound. The expert that was here said that. He's done his modeling as to what's going to be required for the project to be in compliance in operation. And he also testified about what goes on during construction. And yeah, as construction going, I would love this thing to have been done 6 months ago, because the construction is going to be louder than operation. It is going to happen. And I will say that the project is moving toward doing more for mitigation even at this point in time. Getting that sound wall up would go a long way. And that sound wall can be up, I believe, in October. And that will go a long way in helping a lot on the northerly and the westerly side, the easterly side of the property. There was discussion with regard to the LNG tank about being near residential zones. Well, it's not. I mean, the LNG tank is positioned on the property through a siting analysis that was done. It's next to another industrial user, and the only potentially adjacent use is also industrial zone lands. There's industrial zone lands on the opposite side of Lincoln Avenue. That's all industrial. There's industrial zone land right next to the Northeast Precast. It's all industrial. So there really is no, in any proximity to this LNG tank, any residential use. And that was part of the reason why it was cited, where it was cited. Now, Mr. Wendt in his closing brought up, again, the Hamilton ordinance, and he referenced 269 applicability. Now, again, this board is not being asked to make any determination on use. It's not the jurisdiction of this board. Use has already been decided back in 2024 with regard to this property. But when you take a look at 269, before you look at that, you've got to take a look at 268 and in the purposes. And it's established in 268C, established for particular uses or classes of uses. And that's what indicates that the Vineland Code is a class-based code. There's classes of uses that are within it. And when you take a look at 269, when you read it, when it talks about utilizing the word enumerated, well, enumerated is a class. And then you have to actually go into the definitions of what a permitted use is and what a prohibited use is. And when you take a look at those definitions of what a permitted use and a prohibited use, it reads for class and categories, is what it's for. So that particular issue, again, it's an issue that, to me, has been decided. It was decided back in 2024. So the application that's before the board is a permitted use application. The Bloom fuel cells, whether the board
whether they are a permitted principal use or an accessory use, it doesn't matter. They're permitted in the zone, whether it's a principal or an accessory use for it. We did get the review letters, and I believe we answered the questions in the review letters from Mr. Headley's office, as well as from the environmental consultants. We did that through testimony. So I believe we have answered all of the questions that the board's professionals had on this application. And with that, I will close and I will submit to the board.
Thank you, Mr. Fralinger. Before we move to a possible motion, just two quick comments from me. First of all, a couple thank yous to the public that's come out for both of these meetings. I want to thank you for being here, for being respectful of the process, for being respectful of the board members and the staff. Thank you for that. Secondly, to the staff, our staff. It seems like we've had 12 hours of meetings here, but the countless hours of the backwork, the work that's had to be done on this application that our staff had to do is, we can't even measure it. All the information that we've gotten and the work that they've done, so publicly thank our staff for putting that together, and obviously the board members for your work. And again, our work was not just these 6 hours. It's been a lot of work that's been put in on an application of this size. The one other thing I'll mention, and I'll let Mr. Malinsky really comment on it, is, we had a lot of discussion about whether Mr. Steck was right, Mr. Recamp was right, Mr. Perch was right about whether or not this should have been allowed in the zone. Bottom line, and I think Mr. Recamp said it, it was voted, it was approved to come to this board. And that's why we heard it the first time, that's why we're hearing now. So maybe, I'm sorry, Mike, I kind of took a little bit about what we were going to say, but.
Yeah, I just have a quick thing. First, thank you everyone for showing up. It shows that you really care about the community and how you love the city of Vineland. And again, what Dave said, I appreciate that. I am a little disappointed on the atmosphere that everyone feels that you try to have the wool pulled over you. It was. Maybe we could do something better going in going forward with something like this. I don't have all the answers to that, but I think we need to figure this out to get the community involved and get the community informed. Also, Mr. Wentz, I believe, wanted to have Mr. Frailinger's acoustic expert continue studies and do some other tests. I suggest that the two gentlemen here make this happen and see if we can keep the studies going for a while and maybe even through past construction. That's my suggestion. Again, thank you, everybody.
Thank you. Mr. Chairman, members of the board, I appreciate Mr. Fralinger pointing out the additional differences between the City of Vineland and Hamilton Code. Again, as I indicated earlier, Hamilton's code is different with regard to specifically stating for this chapter silent as to the allowance of a use in a zone district. Such silence shall be interpreted to mean that use is not permitted. It goes on to say that use is not permitted in any zone district of the town unless specifically included as a use or category of use in this chapter and in the specific zone district. Now, going to Vineland, as indicated by Mr. Fralinger, it says, nor shall any land use be used for any purpose other than those allowable in each zoning district as designated herein. On February 21st, 2024, Patrick Finley, your zoning officer, issued a letter saying, it is my opinion that the proposed data center use as described would be a permitted use within the IB zone. A zoning permit would be issued prior to the commencement of the use or construction of any structure. This was submitted with the applicant's first application to this board, indicating that this was a permitted use in his opinion. That application was heard on June 26, 2024, wherein the applicant received preliminary and final major site plan approval for a 2,647,628 square foot data center
which was memorialized in resolution number 6652 adopted on August 14, 2024. There was no appeal of that approval within 45 days of publication of that decision. Moreover, there was an amended resolution adopted on March 12, 2025, which corrected an issue with the original resolution. Again, there was no appeal of that amended resolution 45 days from the date it was published. Thereafter, on June 26, 2025, the applicant appeared before the board and a year later, received amended preliminary and final major site plan approval for a 3,129,726 square foot data center, which was memorialized in resolution number 6720 adopted on July 9, 2025. Again, there was no appeal within 45 days of the date of publication of that resolution. So no one has challenged the use or Mr. Finley's opinion of this being a permitted use within our zoning code. And he has determined in his professional opinion that it is a permitted use. So with that being said, the use has already been decided in this matter based on not only Mr. Finley's letter, but his letter that was part of the initial application, which received approval and then was never appealed after the appeal period. And thereafter, a year later, during the subsequent approval, and there was no appeal of that approval within the appeal period. So now moving on, what do we have this evening? We have an application that, yes, requires waivers, but doesn't require any variances. In essence, it's a by right site plan application. So what does the court say with regard to a by right site plan application? Well, it said that the appellate division concluded that under the MLUL, planning board does not have the broad authority to consider a site plan application in light of the general welfare or the purposes of zoning under the MLUL or general principles of sound planning apart from the standards of applicable local zoning ordinances. It found that if the proposed site plan complies with local ordinances and the MLUL, then a planning board shall grant approval. It found that the MLUL, unlike the Planning Act, did not give the planning boards the general power to require that site plans not pose a danger to public health or safety. Again, I appreciate the citation by Mr. Wentz to the 1978 case, but that wasn't under the MLUL. So with that being said, you have an application before you this evening. There are no variances. You've heard testimony from both sides. If the board is so inclined, I'll make my motion, or the motion for the board to make, which would be, and all motions always made in the affirmative, so that a yes means you're approving the application, a no means that you're denying it. It would be a motion to approve the application of Data One USA LLC for second amended preliminary and final major site plan and waiver approval for the construction of a data center on lot 35.01 of block 7503, also known as 3963 South Lincoln Avenue, subject to the conditions set forth in the professional reports and the conditions set forth by this board on the record and as agreed to by the applicant.
Do I have a motion? Second. And before the roll call, I'd ask the members, it's not required that you make comment as to why your vote is, but if you'd like to, this would be the time to do it. Roll call, please.
Mr. Castadia?
I would, along with the other board members, wish to thank all the residents who came out the last couple of evenings to voice their opinion and their concerns about the great city of Vineland. There's been considerable discussion about the similarities between a data center and an office building. I don't know of an office building that has 2,000 boom cells. I don't know of an office building that has a huge liquid natural gas tank, nor one that operates 24/7. This data center is one of the largest, if not the largest, facilities using boom cells in the state of New Jersey. The question that deserves to be answered is are these data centers a terrorist target? Are they going to bring harm to our community? onto our country. A resident brought up earlier CO2. The Pinoni Associates was hired by Vineland, City of Vineland, to give an environmental report. Their report of 5 pages left more questions than answers. The Environmental Commission had many concerns that still go unaddressed. There are many areas of concern, environmentally and otherwise, that need to be answered. It's important not only for the families that live in the immediate area of Data 1, but all the citizens of Vineland. We need a thorough investigation of all the unanswered questions before this project should move forward. My vote is no.
Mr. Mayor? Thank you, everyone. Just to also let you know, my other disappointment is the applications that need to go to the NJDEP haven't happened yet, so I wanted to state that as well. I also, the planning board did get a letter from the director of municipal utilities saying that they have the right to regulate the water that's going to the data center. This was a memo to the planning board dated August 14th. It is a very difficult situation when for the time I've been on this board, let's take cold storage out at Oak Road near Mill when the industrial meets the residential. And this is the result where people have to get together and go through the facts. And the facts is, this is under permitted use with no variances. So with a very, with a long, thinking about it, my vote is yes.
Mr. Zabolski?
I too would like to thank the public for coming out tonight, the last meeting. I hear, everybody saying a lot of questions. Mr. Freeland spent 6 hours the other night bringing professional witnesses out, brought them out here again tonight, tried to answer everyone's questions. I had a lot of questions. I learned a lot just by listening to all the testimony. Everybody was complaining there wasn't going to be enough water, we didn't have water. The water department says we have plenty of water, plenty of water to give them. That 27 million gallons of water a day, a year, is not a big deal for the City of Vineland Water Department. They have much bigger customers. And then everybody was complaining about the electric bills were going to go up. They said they're going to generate all their own electric. It's not going to put a burden on our electric utility at all. And it is a permissible use of property. I have to. My vote would be yes.
Mr. Reel?
Again, thank you for everybody coming out, and I do appreciate all your concerns, but as a board, we have to approve what's in our guidelines, so yes.
Mr. Les?
I too had many concerns, but I'm voting yes based on what's been presented to us. I have questions, and I'm sure Mr. Falinger has listened to the public. Our concerns with the children and school buses and the school buses. At this point, I am going to vote yes.
Ms. Andrioli? Yes. Mr. Odorizzi?
First of all, thank you to the public. As we've already stated, it is a permitted use. We have had expert testimony. We will, as a city and a planning board, watch over this project. My vote is yes.
Dr. Arthur?
I think my point of reference or lived experience is a little bit different from everyone else here. I see this as a plus for the city of Vineland. I taught in the school system, and remembering the pandemic, I think that we need to move forward in addressing that a data center will be coming to Vineland. So I see it as a plus. Do we have all the answers? No. Is there opportunity to improve? Yes. So my vote is yes.
Mr. Catalano.
I have sat through literally hundreds of planning board meetings over my time on this board. And many times my personal and professional opinion differ on an application. But in this case, and actually, to be honest, my personal opinion doesn't matter. What I think, should be built in an area is not up to me. But in this case, where my personal and professional opinion are aligned is that as a city, we could have done much better with this. I agree with Dr. Arthur that this could be a positive for the city. It could be a positive for the city. But looking back through it, and I believe that the applicant has made reference to it, there were things that we could have done much better as a city. More public meetings, notices. We could have had, the maps were up to date online that came up. There were things that could have been different about this application that we could have done differently. I can tell you this, I remember the meeting that we had when Mr. Fralinger came in with this. We were talking about golf courses and possibly hotels or restaurants and other things, and I remember thinking, that's what I would want to be there. But it's not my decision as to what an owner of a property builds on their property.
Oh.
They've changed.
No.
I'm sitting at the planning board looking at the documents that are in front of me. I can't tell someone who owns a piece of property what they can do with it. Would I have liked to have a golf course? Absolutely. The owner of the property decided that they were going in a different direction. I actually believe that you coming out to all those city council meetings, to the town halls, I think made a difference.
What did it do?
They changed the size. It went from 2 million square feet down to what it is now. They changed the fact that they're not taking basically any electric from our grid. They got their own power source. And by doing their own power source, they've effectively used all their property. They can't build more buildings because they basically used it all with the Bloom power. They listened to your questions about the emissions and they went away from the Bergen generators because they heard you on doing that. And I think all of those things, I think they actually did listen to you.
34,000 people. Those kids that died, it's on your ass.
I believe that what they came back with all the changes that they did make, I believe they did listen to you.
10% of the state.
And so my vote on this is yes. So the motion carries.
Yeah, so Microsoft can have federal contracts for mass surveilling, you fucking asshole.